IOCL had indicated on the last day that additional document is required to be filed.
Ah.
But then the record reveals that it is already filed, my lord, in the writ petition. That would be not required. Otherwise, my lord, for hearing, my lord, if it can be taken up next week. Today I have some constraints.
Item 15.
One minute.
Okay, after a week, we'll just not fix a date.
Mala.
Okay.
Yes, sir.
On the prayer of the learned contract parties, list this matter after a week.
Interim order.
Interim order, pass earlier, shall continue till the next date of listing.
Item number one, my lord, part of my one day of commutation, my lord. I was outside, my lord.
What is the issue here?
That, my lord, is my undergo training, my lord, CRPF, my lord. There are Mazumdar is there.
That R. Mozumdar we have
He has
requested.
submitted the other copy also to me.
Okay.
On last time report already directed to him. On Monday, my lord.
Next Tuesday.
Tuesday, I have some division bench case. So,
Monday?
Monday, my lord, at 2.
No, don't say that.
Yes, yes, Monday.
Mr. S.K. Mehdi, Learned Council submits that matter may be listed on Monday. List accordingly. Priya is allowed, list accordingly.
File.
Maybe I prefer listing it next.
You will go to the bench 3, senior bench, court number 2.
This is two,
This bench is taking a civil bench 3. Yes.
May I please your lordship? With the consent on the other side, if I to mention today's daily news, item number 17.
Item number?
17, lordship.
That for 17, that we have given the consent for their convenience method. But my lord, it kept there for a fixed date, my lord, because
This is item number 17 for whom?
time for the petitioner.
What is the issue here?
Dismissal from service.
Dismissal from service, but the 21 matter.
After 2 weeks.
But there is date may be.
You make a mention.
I thought hearing matter, my lord, also on our. So much participation I had, my lord, fixation next.
Give a date after 2 weeks. On the prayer of the Union of on the prayer of the Learned Council for Union of India, matters then adjourned and be listed on 20. Yes.
Item number 3 and 4. Lord.
Yes.
APTCL matters. Document past time orders. I have gone through it. Lord. But I need to make my submission. Can it be placed at what meeting? I have Tuesday. Lord. Next week.
Okay. On the prayer of Mr. M. Bhagavati, Learned Council for the petitioner, matters stands adjourned and be listed on Tuesday.
What you pay order your lordship at page 50. What is the granted pay by what page
That yesterday's method. Yes.
50?
What is the reason? Why?
There was hearing lordship right and the
Paragraph.
paragraph constitutes that's 30 page 60.
Why these matters are listed before this court?
So there is so that it availability arising out of same affair.
First time listed.
It's a record but the position is exactly
Scan copy is received. Okay. Scan copy just call for is not been received. Registry to issue reminder. And
that bail application number 4158 probably record is there. So notice, direct the registry to check that,
In which case?
page 58, what is all standard case.
Okay, list is, okay, right, no, but what is the present status? How many,
Exact same as on today.
have you made any statement?
Yes.
Okay, registry to list this case next week, huh? Give a date next week. Along with,
Here number.
along with the record of 4158?
Lot.
Along with the record of BA 4158 2023, disposed of on 1/12/2023. 7.
The patient does the application. This cannot put directed me to produce the result in Singapore government. I have received it.
Now you have received.
Because my lord, it is under different ministry, my lord. They shifted the office to other place. That is why some delay has occurred. It is under Ministry of Skill Development and.
Okay, give it. What was your name?
Deepak, my lord.
Yes, Mr. Datta, I'm not getting anything. Both of Mr. Learned Council go through it. What is the result? We do not know. There are some marks. Whether this they have passed or failed, nobody knows.
Yes.
Huh?
I'm not aware what is there in.
Go through it. Both go through it. What is this? Yes, what is this?
But, so far my uh, employee skill social studies not available. This paper
So they have failed.
not available. I
They
think
have failed or passed in the apprenticeship.
mark in
Marks we have seen out of 300, somebody got 206, somebody got something. Whether they have passed or failed. I think we need your person to be here.
it's, I have to take inspection because whether he is passed or not.
That is what you want to know. Nothing more than that.
But when the results are called for, the results makes it very clear whether the candidate has passed or.
That is the result. Now,
The
what is
remark-
the result?
In the remarks is some
Pursuant to this court's order dated 25/9/2023 and 12/2/2024, Mr. A.K. Datta has submitted and submitted a sealed envelope which, according to the respondent authorities, contains the result of the petition. However, neither this court could understand whether the petitioner and the other persons has passed or failed in the apprentice examination, nor Mr. A.K. Datta or the learned counsel for the petitioner could enlighten on that point. Accordingly, Mr. Datta submits that he will obtain specific instruction regarding the result of the persons enlisted in the list, though their marks are disclosed. What is the cutoff mark of passing,
Yeah.
whether they have passed or not,
That's
and
my-
tell them,
maybe to find
and
out.
tell them there is a limit to everything. If that is their understanding of a court's order, how they are running the institution? If that is their understanding of a result, tell them we'll take coercive action.
Well,
If this is the situation,
may
list
I-
this matter on.
Mallet, 2 3.
Huh?
After 2 weeks,
Why 2 weeks?
but, I have to communicate it.
Communicate at 2. You need
It
2
is
weeks. Over telephone, communicate them. Send a mail.
I have no, because it is under the ministry of, different ministry, my lord. It is,
Who has given it to you?
where
See the signature in the list.
it is,
Who has forwarded?
under the appendix.
No, see the communication, seal cover. Who has sent it to you?
Yes, my lord, it. Appendix training and culture.
Huh?
Culture.
Then
And some time maybe.
sometime we'll give, but don't be unreasonable. If this is your standard, then we'll compel them to at 2. And call them tomorrow. It's a 1-hour flight from Kolkata. For that, you need three weeks time at this age of technology.
As your lord, please.
Release this matter on, give a date after 7 days,
Let me
10 days, 10 days. 18th of March.
may I obtain a copy of order.
You,
To communicate.
the Learned Council is permitted to download a copy of this order passed today and forward it to President. Nowadays, no permission is
Yes,
required.
my lord.
This is called technology. Okay.
Can be taken after some time.
Why?
Senior council, they could not fight.
Who is represent?
And luckily, on the last occasion, your lordship had directed the department to produce the minutes of the meeting, lordship, wherein lordship the original order was sent by a different corrigendum. That minutes and lordship the
Okay, okay. When?
After some time. lord.
Okay. For the time.
Yesterday, my lord, I received a copy of it. Finally, packet response.
Okay. Need some time.
First time may be taken.
Okay.
And my lord, next day that the original application might that we have submitted it in 7.
Mm.
That may finally be directed to be produced by the government. That makes all things clear. Whether I have actually applied for that, my lord, whose application is actually that application was.
Let you respond. Then we'll
Fine.
decide that.
It's for that.
Okay. Mr. R.M. Dekha, Learned Counsel for the petitioner submits that an affidavit in opposition filed by respondent number 5 has been served upon him yesterday only. Accordingly, he prays that some time may be granted to obtain instruction from his client whether to file a reply affidavit or not. First of clear is allowed. Please this matter on.
But I said,
Give a date after 2 weeks. 19th of March. In the meantime, the petitioner may file reply affidavit if so advised. Yes, Mr. Chaudhary.
My learned friend is having some difficulty. I can
Lordship.
prepare.
Mr. Senior Counsel and TJ Mahanta is another court. After time.
But after some time, you will not find him. Is that it?
Too many cases.
Yes.
This is my instruction.
Okay. It is submitted that Mr. TJ Mahanta, Learned Senior Counsel, appearing for the respondents, is busy in some other court. Accordingly, matters can charge on and be listed.
My lord, may have it that week commencing from 11th, my lord.
Give a date.
Let it be on 12th. Let
12th.
it be on 14th, my
14th of March.
lord. Interim order is here.
Interim order pass earlier, shall continue till date.
Fine.
Yeah. Lordship may taken up after some time, lordship.
Why?
Lordship acting counsel, Mr. H.K. Dasan, late on 4 about 5 lord.
Can I do one thing, my lord,
Yeah.
in this case?
Actually, they have a right of reply as a petitioner. I have only one occasion. Let me place in the meantime, my learned friend will, I'll take some time.
You want to file a reply?
No. I'm for the respondent.
Okay.
I'll argue the case.
Uh.
In any case, he has a right of reply, so he can do it together
Okay,
because
but-
he will get to know my view also, my lord.
yes, he wants to
Abba.
start the argument.
তোমালোকে ৰিপ্লাই দিবা একেলগে এনেওতো তোমালোকে ক'লে মই ক'ম তোমালোকে ৰিপ্লাই একেলগে কৰিবা হ'ব
Good.
দে। মোৰ ফাইলটো ক'ত মোৰ ফাইলটো দিয়া
What is the issue? Sum and
my
substance?
lord sum and substance the issue is
Hmm.
the principal of district institute of education and training my lord
Diet.
are to be filled up
Hmm.
now my lord there is a rule
Hmm.
framed under article 309
Hmm.
DPC has recommended candidates in accordance with the provisions of the rule.
Hmm.
Now, my lord, the petitioner,
Hmm.
who is at serial number 128 of the select list,
Hmm.
who is beyond the zone of consideration, my lord,
Hmm.
she has come up with a case
Hmm.
that for holding the post, there is a requirement of, my lord, PhD degree and, my lord, 55% in MA.
Hmm.
Now, my
Now,
lord,
who are you?
we are all selected persons.
Who are respondents?
I am the respondent.
No, you
And
know,
state,
and state, no private respondents are there,
I'm representing the private respondent.
but there is no private respondent in the cost.
No, my lord, we filed an impleading petition, we are impleaded
Okay,
in the.
but not corrected. Why I am asking this for a specific purpose.
Okay.
Because this fight is going on since long
Ah.
between this filling up the post of the diet.
Ah.
And one group I have continuously represented as a lawyer. So just I want to see
Acha.
who are the respondents.
Okay.
Because after taking some time.
IA, my lord, 2381.
That file the amended post title lordship after I was
No, no,
allowed lord.
that court is not disputing that. Take it up. My lord will kindly come to page
Can I
3
take
of
up?
2381.
Is there anything? I'm not aware.
No, I am also not aware.
Kindly see the names, my lord, Rajen Datta, Nasibuddin Ahmed. Biman Chandra Datta, Lavanya Kumar Das, Mrinal Chaudhary, Rupnath Das, Kishore Kumar Das, Alokesh Datta, Daisy Gupta.
I do not recall the names, but associations, there were two groups. Some,
No, Mala, maybe that the subject matter is different.
the filling up of the post of the principal in
On
that.
account of academic qualification.
All this academic
Only
qualification
one
and
person, he filed 2-3 cases, given to doctor.
Ah.
If lordship appear for him, I don't
okay,
know.
now to I do not find anything. So
Ah.
if you proceed, I'll
Yes,
proceed.
yes.
Okay.
Fine, no.
No, my
Otherwise-
learned friend has come, so therefore
Yes.
that difficulty is also not.
Why I said it after some time you argue and then I say I
Yes.
cannot take
But
it out.
on record, there is no
No,
order
no.
wherein your lordship's name is there.
No. Yes,
No, this is with regard to promotion to the post of principal diets.
principal that, okay?
Yes. Issue is that NCT has provided regulation wherein it provides that for becoming a
Just summary, what is your basic fundamental grievance?
fundamental is that NCT provided regulations
Hmm.
saying that for the post of principal,
Hmm.
you need to have PhD,
Hmm.
MAd with 55% mark. Now there is a service order
Hmm.
which says, which does not provide for any qualification for the principal.
Hmm.
Now NCT regulation came in the year 2014.
Hmm.
In the meantime, in 2020,
Hmm.
2021, respondents convened a DPC wherein they themselves have said
Hmm.
that although NCT is binding upon us, but as a one-time measure we are relaxing
Hmm.
and we are doing by following the old procedure. So far as other posts are concerned, my lord, senior lecturers, they have come up with a change incorporating PhD and MAd with 50%,
Hmm.
55% mark.
Hmm.
Now, again repeating the same illegality, they have held a DPC in July 2023 saying that they are following they have recommended candidates saying that we will fill up by following the service order 2010. Now, this is absolutely impermissible because the this entire scheme diet is of the central government.
Okay. Now where is the
So, in my judgment-
service order?
in my, as per my submission, my lord, they are underqualified. They are not
You
qualified. to
understand,
hold the
your,
post.
your case is that in terms of the, in summary, in terms of the rules holding the field, you are not qualified.
Yes.
This is therefore, your case could not have been considered by the DPC.
Exactly,
This is your case.
exactly.
Now therefore, let us see the
Yes.
a service
First
order
of all,
and whether which one will prevail so far
Yes.
relating. Okay,
first of all, your lordship will kindly come to the service order.
yes, where is that?
Lordship will find page 99.
Page 99. Is there any stay?
Sorry, madam.
This is
Yes.
WPC 496.
4255.
What is this method?
My lord will take up 4255. Yeah.
What about this case to 2023 case?
4255.
No, 4963, Dr. Jibendu Datta, 23.
My senior-
Huh? Same issue. You are another petition. Okay, don't say in the meantime that we need to file affidavit in this case also. These technical issues should be cleared first.
Yes.
Halfway you will say this affidavit, that, why should we waste the time of this court?
Court, like-
And if we apply our mind, we will decide it, that's all.
like it publicly
That
done.
affidavit will cover your case. Have you been, do you need a copy of the affidavit?
Yeah, okay. Okay, okay, thank you.
So you need a copy. That is the problem.
My lord, may I say one thing? Lordship is correct. my lord.
You cannot say anything. If he says, I need a copy,
No, no. If
and you will say, no, I will argue today, make it part hard, he will argue on the next day. He may say, I will file a reply affidavit, who knows?
so far as I am concerned, my lord,
No, I understand. If
State-
issues are same, let us do it in a proper way.
fine, my lord.
We have no problem hearing this method. Today's date is fixed for this only.
Yes. Then they can serve a copy upon him, a short date, it can be given, my lord.
Okay. It would click off 4963. And in this case, Mr.
My lord-
Chaudhury's clients
lord-
are not parties.
My lord, can I make one, that correction office has not made?
No, in this case,
My lord, I have a additional prayer.
Uh.
My lord, Lordship will kindly consider that also, if not put it on the next day.
Uh.
I say, my lord, this petitioner has no locus step
okay, we'll consider.
because he is not a person agree.
Okay.
Lordship will kindly see, in case of promotion, first thing is you have to clear the Hartlock zone of. Now, my lord, if we go by the zone principle, he is not, she is not. So, my lord, first of all,
Is it your case that
assuming, my lord, what she is saying is correct.
no, that
But
do
this
you
is
want
not a
to
child.
Submission of my senior, my lord, I am within the zone of consideration. I can satisfy your lordship.
no, do you,
It is very
anyway,
well.
we'll see, we'll see.
Yes,
we'll
yes,
see.
my lord, I can satisfy.
Lordship
my
will
lord.
We'll
kindly.
keep it,
Yes.
open.
Yes.
No issue. We are not recording anything today.
Yes.
We'll hear it, give a date,
Yes.
since, and Mr. Datta, if you want to file something, you file it. If not, it is submitted that, it is submitted by the respondent, counsel for the respondent state
এটা আমি
that
consider করছি।
the affidavit filed in WPC 4255/2023 shall also cover the pleading of WPC 4963/2023. Full stop. However, Mr. Datta, A.K. Datta, learned counsel appearing on behalf of on behalf of the petitioners in WPC 4963/2023 submits that he has not been served with a copy of the affidavit filed in WPC 4255/2023. Full stop. The learned counsel for the state submits that such copy will be furnished to Mr. Datta during the course of the day. Full stop. Accordingly, this matter stands adjourned and be listed on
My lord, let it be on 21.
20.
So can it-
চালু হয়েছে না না 21st
21st.
Thursday.
My lord, I have to.
Then 21st, Mr. Chaudhary,
Okay.
21st March Bahut here also.
19th of
Okay, let us keep it on 19. I have got so many. Anyway,
Let's
see, my lord,
start.
এটা কই তুই? এটা তো idea.
19th of March
Issue of
2023.
nepotism and
In the
all that
meantime,
sort of-
the petitioners in WPC 4963 2023 may file response if so advised.
On that same Milord, endeavor will be made to
No,
dispose
no,
of.
why? It will be.
Always endeavor. We had the endeavor today
That is
also.
implied.
And hope to, and what is happening, I'll
My
tell you, Miss,
information will-
one senior counsel is here. We have not been able to achieve our endeavor for the lawyers. Every day by one,
We came prepared for the case today, to be honest.
eh,
He also came, I also came.
every day
In
on,
fact, I have taken adjournment of item number 1 in court number 4 to do this case.
what
Today,
to do?
we both Milord, we thought.
No,
that
if doctor could
yesterday
have said,
also
no,
we
I
had
do
that
not
issue.
need, then, but otherwise he should be served with it.
That's
That may be a ground in the upstairs.
Especially this, he is also representing a client.
He is also a petitioner, Milord, equal to me. Milord, there was an interim order that may.
Interim order pass earlier shall continue till the next date of listing.
Highly. Deeply.
So our endeavor is failed till item number
Fine.
9.
So sorry. So sorry.
Kurtu. No? Amati de. Admission হয়ে গেল। Yes, remind us what is what.
That count was, my lord, same name, 2 persons. Corrigendum, by issuing corrigendum, that is corrected.
Okay,
In first list,
But
her-
the name
his-
of the father and other addresses are different.
okay,
It's
so
not a
we said,
correct.
so last year lordship, can you see the last order?
yeah, that
Order
may be
is
granted
16.
time related to produce the note sheets and record including the minutes of meeting of selection committee wherein a decision to issue the corrigendum was made.
Okay.
Yes, sir. Property. Is discussed is scrutiny committee, my lord, there is a note sheet, my lord, regarding provision number. It is not a case that, my lord, one list is typed by a computer operator and another list is typed by computer operator. It is decision making process, my lord, they have put their file for provision number. In a provision number,
No, it's just that- Quickly দেখুন না।
You do one thing. We're taking up after some time.
Yes.
Board, Mr. Das, you also go through. Mr. Mohanto, you also go through. See, our very issue is admittedly there are some allegations, counter allegations and queries. These are fine. This has been given by the investigating officer under his certification that this is the record I have seized. Now, here issue is under what circumstances the corrigendum was issued. If by mistake his name was there, you are very well within your jurisdiction to correct it and issue a corrigendum.
Right.
A list in the name will not give an indefeasible right to be appointed. Okay. But that corrigendum must satisfy that there was this is the reason why this necessitated the issuance of corrigendum by replacing name of TJ Mohanto and in his place Mr. Nath's name is incorporated. Go through that all the councils and respond. Hmm. Hmm. No, that is why. So if that is the reason, we want to see that this is the reason why this corrigendum was issued. That's all.
Yes.
Okay. If there is a marks, because this court under its order dated 28/10/2022 specifically state prints are directed to produce the marks given by each individual members of the
Yes,
selection
yes.
board
That is there.
in the mark sheet made by them on the next date. So that is available.
available.
Now,
And
that decision was taken on the basis of that there was a mistake. By mistake, we have issued the select list. Now let us correct this. If that is their method, hence
And
there.
in fact, that is his pair, my lord. Your lordship can see his pair
No,
Hmm.
on the
my
basis of the
prayer
mark.
is- my
No,
prayer
no,
is
we'll
on
see.
the basis
Please
of the
go. I
qualifying
could not
exam.
identify anything. Just mark it both of you so that there is no dispute as regards the record. All of you see after 5 minutes we are taking.
My lord.
Okay. Then you argue what is your other prayer. Okay, just go through it. Mr. Nath, you also have that individual marks and total marks. Mr. Mohanto, look into it. Next item. We'll close this today.
My lord, consumer later, my lord. Whether that was the part of the, my lord, inquiry, or whether it was exhibited, my lord.
But you give a note. In this matter, I have heard too much.
Respectfully, my lord has taken a tentative view.
No, I have not taken a tentative.
On the last occasion, my lord had indicated, my lord, because the report otherwise is based on a consumer ledger. And admittedly, that ledger was not part of the department. So I'll fairly admit to that, my lord. May I only, my lord, if my lord is tentatively otherwise inclined to interfere in the matter, may I pray that it be remanded back? Because the issue in question, my lord, if I may submit.
He is still serving.
He's still serving. He's still serving. And otherwise the charges are, there is a lot of gravity to the charges in the sense that public money has been misappropriated. my lord. If that issue, that charge, my lord, if we can relocate it from the stage of the submission of the order, furnishing of the charge memo, we can do it afresh from that stage.
My lord, it's
And on that point also, my lord, I'll place a judgment, my lord.
De novo.
Not de novo, my lord, remanding back the matter. De novo would perhaps not be applicable in this case. Para 5, my lord.
Yes.
It is a right law, my lord. Next sentence thereafter, my lord. Mama, I'll read it for the first line itself.
it is tried to say that the domain of the court on the issue of quantum of punishment is very limited. It is the disciplinary authority or the appellate authority which decides the nature of punishment, keeping in mind the seriousness of the misconduct committed. This would not imply that if the punishment is so disproportionate that it shocks the conscience of the courts are denuded of the authority to interfere with the same. Normally, even in such cases, it may be appropriate to remit the matter back for consideration by the disciplinary or appellate authority. Otherwise, the punishment here, my lord, is for recovery. There are two charges. One is of unauthorized absence, which respectfully stands proved, my lord. And the second is as far as misappropriation of the board's money is concerned. That charge, otherwise, if the document would have been furnished, that charge would have proved.
Would have,
Would have.
both would
So,
have and could have.
Yes, my lord. So the punishment otherwise is not disproportionate to the sense that, my lord, that money that
No,
recovery
here is not a question of punishment. Here comes whether there is any perversity.
Yes.
Until and unless it is perverse, we cannot, if you have a minimal of evidence
Yes.
to establish, we cannot go for sufficiency of evidence.
Right, yes.
No sufficient, we cannot say that this evidence is not sufficient in a departmental proceeding. Our limited role is any procedural impropriety.
Correct.
First.
Yes.
And second is if there is a question whether materials were there to come into such a conclusion, meaning thereby his whole case is the ledger
Yes.
where manipulations were done.
Yes.
Now, if ledgers is not there, what are the other evidences on the basis of which you have come to a conclusion that it is he who has done it?
there are witnesses we have gone on to
Witnesses on basis of oral witnesses.
witnesses. There is an account officer also who looked at the. I'm not saying that the
No,
penalty order.
you can still argue
Yes.
that there are there were evidences.
Yes.
It's not a case of sufficiency of evidence.
Yes,
Laser may not be there.
Yes.
But these were the evidences on the basis of which the employer has come into a satisfaction.
Yes.
And Reed Court will not evaluate whether that evidence is sufficient or not. Only look into the perversity. And what is the definition of perversity? Perversity
No
means no evidence or or materials which on the basis of which a reasonable man will not come into such a conclusion.
Now, my lord, here is a case where there is a report. There are witnesses who go on to state that there has been misappropriation, there has been manipulation of the ledger, but the ledger, admittedly, my lord, was not part of the documents that were placed before the purview of the inquiry office. Now, the charges of
Okay, now what you propose from this paragraph 5?
what I am proposing, my
That
lord,
interfering with giving you a liberty to have a
that conduct because the offense otherwise, the charges otherwise, my lord, is of a grave nature. Now, if respectfully, my lord, should not be a case where someone who misappropriates public money is allowed to go scot-free, my lord, based on a technicality, my lord. Let us conduct that inquiry, my lord.
conduct the inquiry from what
the
stage?
stage of the document, my lord. Will punish him the consumer.
Is it permissible? If we say that you do a inquiry from what stage? What the law says?
Document stage.
What law says? What law
The
says?
document stage.
What law says?
That is, madam,
When it,
to
see, it is kind of you are proposing a de novo inquiry.
not a de novo inquiry to the extent that, my lord, we are only going to submit.
Give us the, okay, we agree with that. Paragraph 5 says, even if you think that this punishment is disproportionate, remand this matter back to the employer. Let the employer decide. Then again he can come. Suppose there is a dismissal. We'll interfere with the dismissal and we'll say, okay, this is, if it is on the proportionality, proportionality test, then we'll say, okay, this is disproportionate according to us. So therefore it is set aside. You are at liberty to impose any penalty except dismissal. That is, you will decide what should be the other.
Here, my lord, there is that penalty.
That will come when we are satisfied that yes, everything is established, but we think punishment is disproportionate.
Disproportionate.
Do you want to say that the punishment is disproportionate?
Punishment otherwise, my lord.
Punishment was what? Increment.
In one increment and recovery of 37,000. There are two charges, my lord. One respectfully stands proved. As far as the charge of misappropriation goes, my lord, on a technicality, my lord, because the document was not furnished to him, such charge perhaps, my lord, has to be revisited. So I am only praying, my lord, has the
No,
powers
no,
under
not
20
document was not given him is not the issue. Issue is document
document-
relied upon on the basis
Document-
of a document on the basis of which a punishment was imposed was not a part of the
Yes,
procedure.
my lord. So let the department, my lord, let the board submit him the document. Let him give a defense, my lord, on that document.
So therefore it is a de novo. It will start from the date of SARS,
From the,
farming SARS.
or to that extent, only that charge itself. Because the charges, my lord, the allegations against them are quite grave, my lord.
Mm.
It should not be a case where someone is allowed to go spot-free, my lord, after misappropriating money.
No, no, nobody. We are not at all interested giving a person spot free.
Yes.
We are not an appellate
My
authority.
lord.
What we need to look into any procedural lapses, or when it argues that it is perverse, we'll see whether it is perverse. We'll not go for a sufficiency of evidence. That it is insufficient or not to have been punished, that will not go.
Yes.
But if you yourself has failed to prove a grave misconduct according to you, is it the responsibility of a judicial court having
Yes, sir.
judicial review to look into the matter and give you a handle? You are not the petitioner, they are the
They are the
petitioner,
pet-
isn't it?
This is my,
So our limited scope will be to look into procedural impropriety, and since he has argued that these materials were not there, they could not have come to a conclusion that I am the person who has done it. His argument, if I could understand, that the basic fundamental thing was every witness said that it is done on the basis of the ledger. Ledger was not before it, and some witnesses said even we do not know who has entered in the ledger. So therefore there is a dispute who actually done it. If ledger would have been there, everything would have been completed. Now you say that let us do first afresh by producing the ledger. Then it will be de novo. De novo will
then,
be
my lord,
from
may I just pray then, my lord?
de novo will be from the date of SARS.
Lord, then I may-
Admittedly, it was not there.
Yes. This is another judgment that I pass, my lord, because my lord will see there are two charges.
Hmm.
There are 7 for a moment, my lord. We'll
Hmm.
see. I'm reading from the.
Give short written note
Yes.
so that we can record your
Yes, my lord.
argument, and
I will-
and you do not say that this judge has not recorded our submission.
We'll provide, my lord.
Huh? Short.
Yes.
It's not that long is written argument. What are your points?
By tomorrow we can get.
Yes.
My lord, placitum D, my lord, here.
Placitum B.
D, my lord. D for
D.
Delhi. Yes.
Okay.
It is
Page
para 7, my lord.
para 7.
Yes. It is
Para 7, placitum.
D, my lord.
This is
State of UP and others.
state of UP.
Yes.
Okay, D.
Yes. It is settled law that even one of the charges,
Hmm.
if held, proved, and sufficient for imposition of penalty by the disciplinary authority or by the appellate authority, the court would load to interfere with the part of that order.
Yes, of course.
So, my lord, that one charge stands proved.
Which
No.
was which charge?
Charge of unauthorized absence. Admission, my lord.
Mr. Das, we are so excited.
Yes.
We have given you patient hearing.
Sorry.
Huh? Don't jump.
Yes.
We'll ask after a few minutes, we may also ask you some questions.
Yes.
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 Then only we can come to the just conclusion. Yes.
Now, the charge of unauthorized absence, admittedly, my lord, is proved. My lord has seen the document. He goes on leave, doesn't return.
Hmm.
There are 3 periods, my lord, of absence. First is for a period of 10 days. That is 28 days. And thereafter 5 months.
Hmm.
And there is no document on record to show that he had availed permission from the authorities or his supervisor
Hmm.
before going on such unauthorized.
Hmm. Okay.
Now that
Let
charge-
us just see the search first.
Yes.
Unauthorized absence.
Yes, my lord. Page 41. is
Statement
the-
of allegation.
yes, my lord,
Statement of allegation.
allegation from our court. It's page 25.
Page
Starts
20.
at page 24.
Huh? Search page 20.
Starts at page 24.
We want a statement of allegation so far relating to unauthorized absence.
Yes,
Page 25. my lord.
25 is the statement of.
That's number 1.
Okay.
Habitual net. Okay.
Where is your reply? To the charge number 2?
WSS at page 30, my lord. This is a little haphazard, my lord. He's dealing with both the charges simultaneously. Page 30, last
30.
sentence, my lord.
My controlling officer did
Ah.
not believe me that I was suffering from chronic sinus also undergone operation once acute stage that was in a strong headache, but it gave regular test. I also ready to equip but it doesn't. Next one. Next one. Here I would take number. My lord, last one 8 line, my lord.
The SD used to,
SD,
we have marked it already.
yes, my lord, I had to refuse my CL application and it like it asked me to submit only application. If I would submit only application, then he would ask me who will take this charge. I will was put it. SD was always insisting me to collect my pay. These are the matter company who
Page 34. Page 34, my lord. Top of the page, thus I felt unsecured gradually and my sinusitis problem also got aggravated, giving me strong headache. I had submitted one CL application for the SD, so and so, my lord. Then thereafter, the same paragraph was the bottom, my lord. I had to visit Boripur Community Health Center on 4th March for treatment. I felt essential to get better treatment at Guwahati and thus submitted EL application from so and so and sent 2 telegrams thereafter for extension of my EL, which cannot be treated as an further. The senior manager refused my EL application and reported the CMC that the application was not accepted. I don't know where the so and so. Then next paragraph, my lord. Next page.
Thus it was apparent.
Yes. My lord. The report, my lord.
And now, my lord, the one witness, my lord, witness number 3, page 67, he stated, well, these are my letters for CL, my lord, he exhibited, man. The general manager, page 67, man. Exhibit 8 is the letter dated 25 to 2008, seeking mention of CL by the charge officer.
Who is this witness?
My lord, he is-
Management witness.
the management witness, they themselves say. Exhibit 8 and Exhibit 1 is a signature. Exhibit 9 is the letter 27 to the written by me addressed to charge officer. Exhibit 9. Exhibit 10, kindly important, my lord, is an EL application. All these applications, my humble submission, my lord, before the authority, and they themselves, my lord, exhibited these, my lord. And in such cases, the Kusanbi Parmar case is very on the point that the public person may have difficulty.
Yes, and which paragraph now?
Yes, I marked the paragraph.
No. Yes. Chaudhary, your paragraph, which paragraph you want to rely on this judgment?
Paragraph 7.
Naresh Chandra, paragraph 7,
State of UP, my lord.
state of UP.
Yes.
Okay.
Paragraph 7.
Okay,
Section
that is
3.
correct. You are correct. on.
Yes. Now, that management witness number 3, my lord, has duly been, his statement and everything has been considered by the inquiry. They go on to give a finding that he was in the habit of going on leave and then informed. And the last, he submitted an application, and the third period, my lord, is mind-boggling. He remained absent for 5 months. That also why he was absent for that period. There's no document to support.
What is the service regulation so far relating to these people as
No,
discipline and
I'll explain.
appeal?
Yes.
At the time, my lord, some state electricity board
Yes,
employee
I have that.
service regulation 1960. And my lord, rule 10, my lord, disciplinary action and punishment.
10.1, my lord, it's the rule pertaining to disciplinary action and punishment. My lord. Now, my lord, at E,
Mhm.
10.1 E is absence without leave or worse.
I have marked it.
Yes, ma'am. Now, my lord, the punishment
Hmm.
are at 10.2, my lord,
10 point. Page
page 12, my.
12,
I'm sorry, page 13,
page 13.
2S. Without prejudice to the provisions of any law for the time being in force, any of the following penalties may be imposed on an officer found guilty of misconduct: warning, reprimand, or censure; stoppage of increment for a specific period; fine; reduction to a lower post or to a lower time scale or to lower stage in a time scale; 6 is compulsory retirement. And then, my lord, page 14, termination of employment, dismissal,
Hmm.
notwithstanding anything contained in subsection so and so, a recovery of loss recovered to the board through negligence or breach of orders from the pay of the officer up to such extent as may be decided by the competent officer.
Okay.
मतलब that's what as per I'm forwarding matter that Kutanti Parmar Malapati Sonabul court was also Malap observed and allowed to set it status at the Malap on the ground of written submission with on the
It could be. Discussion, center, please. Want to relay anything?
No.
Uh, the learned counsel for the parties have concluded their argument. However, submits that they would like to furnish written note of arguments. Prayer is allowed. Please this matter on 18th of March 2023, 2024 for delivery of this. You
On
give in the meantime, we'll
18th
dictate in the court itself so that no confusion remains.
My lord,
sure. Obliged.
I'm deeply obliged.
Give a short note so that we can in the meantime
Sure.
do some homework.
Deeply.
Yes, Mr. Mohanto? Okay, okay. Okay. Engineer,
Yes, ma'am.
what was the challenge here?
My lord, this actually submit my lord.
Huh?
When my lord took up the matter on 8th of this month, my lord observed the following. Firstly,
Hmm.
my lord educated us saying that probationary period is only for the NT level only. If there is a
Everything is done out of it. You
okay, my lord then made a mention of Provadevi order judgment. So judgment I have got, and then my lord clarified us how that the relaxation, my lord, 96 later of POPT, how it came into being.
Hmm.
That to express to us, educate to us, my lord took a reference of Provadevi judgment, wherein the Supreme Court stated if the rule is framed, the Supreme Court is not able to change the rule. Rule has to be followed. But GOPT is empowered, being a nodal agency, to form a policy for relaxing the norms of promotion subject to the condition as laid down in 1996. My lord, this subject These are the three. And my lord asked me also what happened when my lord passed an order. There are two players. One player for holding review DPC for still cover procedure because he became under cloud that point of time. And here, my lord passed order favorably on 25th of April 22. But since the date of compliance not given, they did not comply. The point was raised by learned senior counsel K.N. Chaudhary that before filing contempt petitions, he raised before Justice Suman Sam the issue that they did not comply the order. Then the Union of India stated that he did not meet the QR. Means RNP rule what QR is given as command 10. Then petitioner also, that case, my lord, is dealt with by K.N. Chaudhary 6292/21. Then petitioner also filed the counter. Still it is pending. They have not complied with the order because no date is given, so 1 month's time, 2 months. But my humble submission, presently I am concentrating on the issue of non-functional law. And that part where my lord passed an order for holding review DPC on seal cover, because of the reason the petitioner was under cloud, that point, that key parameters fulfilled, suspended discipline, case pending, and criminal KB Janakra. Here, my lord, I am entitled to be considered for non-functional law. That concept has been brought by the 6th Pay Commission, my lord, with their letter 24th September 96 for the organized cadre of. I'll just, if my lord permits, I'll briefly explain the non-functional law, just in 2 minutes. Ma'am, there is a stagnation.
Proceeding final disposal?
Yes, ma'am.
Yes.
My lord, there is stagnation in organized cadre.
Now let us see first, what is the criteria for functional upgradation?
Non-functional. Yes,
Non-functional.
I'll draw my lord attention to the policy level. Updated 24th April.
No, as
September
per
96.
my understanding,
Yes.
that these are the criteria on fulfillment of which a person is entitled.
Whether it
Okay, now first we will see what are the criteria.
Right.
Secondly, whether you have qualified those criteria.
Yes, ma'am.
And if you have qualified those criteria, why you have not been granted?
Yes.
These are the 3 stages. So let
and
us.
then 96 policy.
So therefore, first 6, what is the criteria?
Yes.
For non-functional
Yes.
upgradation?
I draw my lord attention.
Where is that?
The page 36 annexure 5. My lord, before my lord goes to the paper, if I am permitted, I beg to submit briefly the concept. My lord, there is the organized cadre officer, and this petitioner joined border road organization. The
Yes.
petitioner joined border road organization, my lord, on 20th March 1990.
As
Assistant Executive Engineer, appearing to combine engineering service, which is known as organized service, because of the reason that in organized service, there is a post of joint secretary having a gateway of 10,000, my lord, with reference to 6 company. My lord, then the petitioner became executive engineer
when?
on 1st August 2000. Then, my lord, the petitioner became superintendent engineer on 26 August 11, 2008. My lord, as per the recruitment rules of 1988, for the next promotion,
Yes,
to the rank of chief engineer
yes, but
a superintendent engineer is to have a command tenure.
yes.
Command tenure. So, and the
Command tenure
period
of
command tenure is 2 years.
command tenure of
2 years.
Hmm.
So, my lord, out of total for being chief engineer, he is to have a 17 years of service. With I'll show my lord the recruitment promotion route which I have enclosed. And out of 17 years, my lord, 2 years should be a command tenure.
Hmm.
At par with the army like brigade. and
Rule-
the command.
rule-
No matter what,
rule.
1988 recruitment.
No, no, what's a specific rule?
Pagination, my
No,
lord.
not pagination. What is the specific rule?
The border roads recruitment.
No, no. Rule 8, Rule 9, Rule 10. Which rule prescribes?
Rule 1988.
Huh?
Lordship will see the rules of 88, column 12.
Column 12, 1988, page, my lord, 22. Of my district.
Okay.
What happened, my lord?
Uh.
He had done the command tenure from 26 August 11.
26.
August 11.
Promoted as SC
Superintendent engineer 26 August 11.
11. Okay. Now command from
Before that, he was official.
officiating from
executive.
which effect from?
Then 26 August 11. Same day.
26, 8,
11.
11 to
19th 13.
19,
19th March 13.
19 March 13.
13. So, my lord,
this was command
command tenure.
officiating.
No, a full command tenure. Before that, he also officiated. My lord, so
what is the period then?
what is the 1 year, 6 months, 25 days? 1 year, 6 months, 25 days.
And officiating?
Instead of 2 years, my lord.
Officiating?
Officiating, my lord, 11/4/11.
11/4/11.
To 25 August 11.
25
August 11.
11. That is how much?
That
4 months.
is, my lord. But that his rank was executive in.
Okay.
Because he was promoted on 26 August 11 as superintendent.
Okay.
As my lord desire to know the
Now this is for the promotion to the
Chief engineer.
chief engineer.
Chief engineer.
Now we are on officiating.
Prior to the 2 months officiating as the executive engineer.
No, not officiating. We are basically not on promotion to the chief engineer.
Yes, my lord.
We are basically in this repetition dealing with non-granting of that non-function.
My lord, the QR is same. That is why I am taking to submit that QR of the
was
chief
in
engineer.
a lower.
Selection procedure
No,
same.
No. So you say that for non-functional also these are the requirements.
Yes.
Okay.
So, and non-functional is the next target, that is chief engineer.
Okay.
Actually, my lord,
You will get a scale of chief
10,000 gate payment. That is the chief engineer.
chief engineers as non-functional.
Yes, ma'am. Because there is a style.
If you qualify, otherwise the
I'll be a normal chief.
no. If you let me understand, is it your case that these are the qualifications from promotion from chief engineer from superintendent engineer to chief engineer? That is, however, the same qualification and requirement is prescribed for granting a non-functional upgradation.
Yes, ma'am.
Is similar.
Yes.
So therefore, according to them, you are not having the minimum qualification. Therefore, you are not being granted.
Yes, ma'am.
This is your case. Now,
yes.
what is your answer to that?
Yes, ma'am. My lord, I am now. My lord wanted to know the concept of non. Because my lord, I beg to submit the like SCP, MSCP, non-functional upgradation which is applicable to the officer rank of organized cadre is a beneficial proposition. SCP, MSCP is the beneficial proposition.
Now you tell us under what circumstance, why this non-functional is provided? And
Yes,
to whom?
that is, yes, I draw my lord's attention.
Page 36.
Page 36.
Yes.
Briefly, I'll explain, my lord. Then I'll read between the lines. My lord, what happens? There's a stagnation of organized.
The
service.
reading between the lines is very difficult. We should have a clear lines.
Yes,
The lines between creates
I
the
bowed
whole
down.
problem. Yes.
my lord, this is the
So write clearly, don't write the lines in between.
Okay.
Yes.
my lord, there's a stagnation in organized cadre of organized cadre officer, such officer who are having a post of joint secretary. That is 10,000 great pay of 6 pay. So 6 pay commission, my lord, conceptualize and UPT put it at a later lord on 24th September 24th April 2009, my lord. Page 36. Stating the parameter how and why non-functional arbitration should be taken. My lord, I read Roman 1. That's very important, my lord. Then I'll go to the example. Whenever an administrative service officer of the state or joint cadre is posted at the center to a particular grade carrying a specific grade pay in pay band 3 or pay band 4, the officer belonging to the batch of organized group-based services that are senior by 2 years or more and have not so far been promoted to that particular grade would be granted the same grade on non-functional basis from the date of posting of the Indian Administrative Service officer in that particular grade at the center. My lord, I beg to explain it further, this fact.
So let us therefore
My lord,
Layer-
I beg to explain why deputation.
this clause 1. Now let us see what is the condition precedent.
Yes, well, I'll come. Well, what happens in central government, there is no IAS officer as such. What happens? State or joint cadre. If the Indian Civil Service officer manages 2 states, they are known as joint cadre. Assam, Meghalaya. There you put it to. Similarly, one cadre is there that is controlled by the Ministry of Home Affairs, IGMUT cadre. That cadre is also posted Union Territories and Andaman, Goa, Manipur, Union Territories. They are also posted on the. Now, to explain to my lord's query, I draw my lord's attention to page 41.
So therefore, juniors are promoted, they are not promoted.
No, my lord,
Therefore, they will be given a non-functional.
no, my lord, what
Is not it?
Yes, my lord. To add more to my lord's thought, I
No, it's not my thought. I think this is
Yes,
the
ma'am.
thought of
DOPT.
clause 1. DOPT.
Clause one.
DOPT says
And
these
that-
administrative officers who are at wherever, their juniors are promoted and they got the next higher level, but these these persons are not promoted. Give them a non-functional wherever they are.
Subject to the condition, my lord, page 41. I draw my lord's attention to page 41, which is now they have exemplary.
No, before that,
Page
page
41, that will be very clear to me.
no, thereafter page 39. Clause 3.
Place 38 terms and conditions. Yes, that is also as a
Very essential.
Yes,
What are the conditions?
condition. My
Phrase clause 3
Para
says
C, my lord.
all prescribed eligibility
All
criteria and
prescribed
promotional norms,
promotional norms,
including
including
benchmark for upgradation to a particular grade, pay would have to be made at the time
Yes,
of
my-
screening of the grant of so.
Page 4, my lord. Then para 4.
Therefore,
A screening committee would be formed by the Ministry for implementation of this order. There should be 3 members in committee. This is very important, my lord. So formed, and there would be at least be 1 level above the grade for which upgradation is being considered Secretary of the ministry concerned would chair the committee.
Okay, these are the form, like kind of a
This is a
DPC.
little different than the normal DPC. In normal DPC, UPSC is consulted for the officer, my lord. Here, UPSC is not consulted, only one level up. He will be chairing the screening committee meeting. They say it is not a selection committee. It's a, I stay screening committee because it is a beneficial proposition. So what is happening, my lord, for the chief engineer? Only in the rank of additional secretary officer will chair the meeting. That's the meeting. Now I draw, my lord, these parameters are clear to my lord. Now screening committee concept, because of beneficial nature, they have cut short a little because there is no involvement of UPSC. Only one level up officer will be chairing the meeting. Now I explained to my lord, page 41. What is the another criteria to be fulfilled by the organized cadre officer? My lord, if IAS officer, the organized cadre officer has to be 2 years senior to the IAS officer of the batch who are deputed to. For example, they have given the example, my lord.
At page 41.
Page 41.
Yes, I've read it.
The 87 batch. They should
They have
be
clearly said
85,
that all 87 batch, if one is promoted,
85 batch.
other all 85 batch should be given a
The same,
functional,
they will not be promoted, given
Give
the
it a
same non-functional grade.
non-functional
What the IAS did.
but that should be subject to the clause paragraph 3.
Paragraph, the screening. Yes.
Not screening committee. Screening committee is 4. Parameter.
Selection committee. Now, my lord, I draw my lord's attention to the RN.
Now the whole question therefore boils down is whether you are having the
Quality. Yeah,
criteria.
Quality.
Hmm.
Yes, my lord. The requisite qualification, my lord, I have been
because your juniors are promoted to the chief engineer or granted non-functional,
then I am eligible with reference to
that you are eligible according to as in terms of
1996 DOPT guidelines. That is my case before my
where is the DOPT guideline?
DOPT guidelines. Yes. DOPT guidelines I have cited here, my lord.
Hmm.
First, that is page 50, my. My lord, page 51, last paragraph is very important, rather than reading the whole point. I can read, my lord.
No, this is your representation.
Representative annex, otherwise also, my lord, I have quoted in between in the
Okay.
read also, my lord.
Okay, page 50.
Page.
Page 50, the memorandum starts.
Page.
Okay, which one you want to?
My lord, page 51 I want to read.
Okay.
Where juniors who have completed their qualifying eligibility service are being considered for promotion, their seniors should also be considered, provided they are not short of the requisite qualifying eligibility service by more than half of such qualifying eligibility service, more than half, or 2 years, whichever is less, and successfully completed their probation period for promotion to the next higher grade along with the junior. My lord, as far as the probation period is concerned, it is on the group. If somebody in the group C, he has to complete the probation period.
Now your whole case is that though I am not 2 years, but I am 1 year, 6 months, therefore I have completed half of 2 years.
Yes, my
Therefore,
lord.
my case should be considered by the committee constituted under that.
Yes, and that too also, my lord, I am claiming my stake for non-functional upgradation with reference from 1st April 2014. After that, what happened, my lord? 1st April 2014, last date of hearing, my lord noted it. When my juniors was promoted with reference to inter-seniority. One is Saha,
With effect from
1st April 2014, my.
because you have completed 1 year, 6 months on
25 days.
19/3/2013.
Yes,
So therefore, and your juniors were promoted on 1/4/2014. Therefore, on when your juniors were promoted, you had all the qualification except the 2 years posting,
yes,
which according to you was 1.6, 1 year, 6 months, more than half in terms of page 51. Therefore, your
Yes.
case should be considered.
yes, my.
That
I
is your
bow down
case.
and submit one point. Why my lord directed in another prayer that is called holding a review DPC for seal cover? Because subsequently the officer became under. Not on that point. I have handed over in the last date of hearing a DOPT order which says
Now
in
tell
the
me what is your final prayer in this regard?
final prayer, my lord, criminal case cognizance to be taken. Criminal case is set to be started when the cognizance is taken. That DOPT guidelines to 1/14, no cognizance was taken. I was not under. My
When the affair was lost,
my lord, if enter FIR lodge, my lord,
On-
I read from the
don't read, tell us the date. These
Yes.
dates are very
my-
important.
is-
FIR was
is-
lost on,
is very important, my lord. Yes, my lord.
FIR was lost on.
Yes, my lord, I read from the counter affidavit text date.
Tell
Yes.
us, why
Yes,
should
my
you
lord.
read?
Yes, my lord.
You know, we
Yes,
don't have the
yes, my lord.
luxury
Yes,
of
my lord.
time.
Yes, my lord.
Yes.
Yes, my lord. CBI lodge FIR page 2 of the counter affidavit.
Date.
Date CBI 17201 number 17201
Two,
17201 CA TB04.
Date
Date is my love book number dated 20th 2030.
28,
20th March 2030.
28 March.
20.
Yes, 2003
30.
13.
Yes,
2013.
my lord, I
When
come
you were posted,
in there.
It-
Firma 76.
okay.
Yes.
Now you
My
were
lord,
arrested.
I now subsequently I read from their affidavit page 3, my lord.
No, don't read, tell us. Then
And
happened?
the petitioner was placed under suspension on 20th 13 to 76/13,
Suspended.
20th March 13 to 76/13, because the date when the FIR was lodged, my lord.
You were put on deemed suspension on 28th of
Yes,
March.
yes.
Then when suspension was revoked,
Revoked on 18th, suspension revoked 18/6/13, my lord.
revoked. Okay.
Yes, my lord.
Then
CPI submitted the final closure report on 17/12/30.
17,
12/30.
12, 13.
Yes, my lord. Then what happened? The trial court, while agreeing to accept the final closure report of 17/12/13, went on to hold that the evidence collected by IO so far against the accused petitioner were not sufficient for launching prosecution by order dated 5/6/2024 and directed the investigating officer CBI to submit the charge sheet against the petitioner for acquiring the asset disproportionate to the known source of income.
Okay, now
What happens subsequently?
this is the order of the learned trial court.
However, the trial was stayed by the Guwahati High Court order dated 16/6/15.
What is the date of the trial court passing the order? You are reading the order. We want the date of the order.
The order dated 5/6/14. It is 13 detained, but it could be 14.
Okay. Then this against that
I am reading page 4 of the counter.
You came before this High Court.
High Court, yes, my lord.
High Court stayed.
Stayed by order dated 16/6/15. In criminal division petition number E.
Now what happened?
Criminal division petition.
Okay, what happened there?
The stay was vacated again on 18/4/17. High Court vacated the stay.
Mm.
And the trial is under progress now, my lord.
Mm.
And the trial court took cognizance on 3rd 12/2018.
Cognizance on
3rd of December 2008.
now what is this order of 5/6/2014? It was SARS framing of SARS.
That is the trial court order, my lord. That is
Trial
the-
court framed a charge. Being
Ah.
aggrieved, trial court framed a charge under reports under PC Act.
Yes, my lord.
You were aggrieved.
Yes, going
Then
to the High Court.
You came before the High Court. High Court stayed.
Yes,
Then High Court dismissed your criminal petition.
vacated the
Vacated the stay. Now the trial proceeded.
trial
Now,
proceeded.
where is the question of separate cognizance on 3/12/2018?
My lord, the trial court now took cognizance on 3rd 12/18. Charge sheet
Is
they
it-
accepted.
Huh?
They accepted the charge sheet on 3rd.
Now then, what is the order on 5/6/2014?
5 is sufficient launching. My lord, this is this order. I have submitted one sheet, my lord,
Huh.
that depicts or history of the trial.
No, we understand.
My lord, I do not have the copy.
No, you need not have the copy. On 5/6/2014.
Yes.
There is a FIR.
Huh.
Investigation completed. CBI files final report before the court.
Close
On the basis of the final
close the report. Yes.
final report, the court
70/12/13 CBI filed a closer report.
then closure report was not accepted.
The trial court, while agreeing to accept the final closure report dated 70/12/13, went on to hold that the evidence collected by IO
Ah.
so far against the accused
Okay.
petitioner
Ah.
were not sufficient
Ah.
for launching prosecution by order dated 5/6/14 and directed in the investigating officer CBI to submit the charge sheet against the petitioner for accumulating asset disproportionate to-
Understand?
And then it came to the High Court. my lord.
CBI says say no case.
No. Trial court said no, go ahead.
Tricol says no. Though you have given final report, we are not accepting.
Yes,
There is sufficient material to proceed against you under PC Act.
Yes, ma'am.
Isn't it?
Yes.
Now accordingly, court proceeded with the PC Act.
PCA, but I went to the High Court.
Yes. So therefore, that order itself is a. Where is the subsequent cognizance? That is, I am not understanding.
My lord, subsequent cognizance that
Where is the question of subsequent cognizance?
cognizance means then High Court
Okay,
state.
anyway.
High Court
Okay,
stayed the
okay,
order.
3/12/2018. Then
High Court
tell us.
stayed the order,
Then tell us. Then tell us. We'll look into it. Then tell us.
And now the charge sheet filed before the learned special judge CBI edition on 28/18, my lord. Final charge sheet. Final charge sheet submitted. I am reading from the counter affidavit.
12.
29/8/2018.
Hmm.
Final charge sheet there, and the trial court is still under progress, and the honorable judge took cognizance of the charge only on 3rd 12/2008. That is why the date is corroborating. 28/8/18.
Okay,
And
understand. Now, what is your case?
Now, my case is that
Hmm.
since with reference to 1996 UPT guideline, if junior to be promoted, I being a senior to the junior of 2 officers whom I have mentioned from the list of seniority vis-a-vis the order of the 1440. I also to be promoted. I also
What
to be
the laws-
granted,
what-
not promoted, granted to the
Non-functional.
gate.
What the law says as regards pendency of a criminal case and your right of promotion during that.
My lord, yes. On 1/4/40,
Hmm.
was I under these circumstances? Yeah,
No.
with reference to
No,
KP
no,
Janaki
no,
Raman case?
no. On 1/4/2014,
When I am entitled to be considered for
on
non-functional.
on that date, there
I
was
am to be considered for
on
non-functional.
1/4/2014, you
I-
were 1/4/2004, prior to 1/4/2014, you were arrested, you were suspended.
I accept it. That is over. Fire.
Suspended.
Yes.
Now, what your service rule provides in such a situations, your right either to promotion or to functional upgradation.
Yes, I'll come.
That much.
Yes, yes,
That much. If you have a right,
Yes,
that is not a bar, then they will have to consider. If there is a bar,
yes.
then they cannot consider.
Yes.
That's all. Then they will have to consider under seal cover and keep it pending. What the rule says that is.
Yes, ma'am. Yes.
So now we have come to the lines.
Yes.
Now we'll not go to the lines in between.
Yes.
My lord, repeat indulgence, my lord, item number 16, my senior counsel is here, my lord. We are taking a date, my lord, of 14th next month. Today,
Why?
my lord, today I have technical issues, my problem.
Okay, 60.
Fine, my lord, but there is thing inside. I have to go back now.
Okay, you collect your guns, bullets.
Bullet, my lord.
Yes. Okay. 14th of March. 14th. That's it.
I respectfully submit as my lord asked the question, what are the parameters? Why is to be considered for selection grade, upgradation or not? Now I draw my lord's attention to page 35 of my rejoinder.
Yes.
35. I have cited the DOPT guidelines 14 September 92.
35 of your additional affidavit.
Yeah, rejoinder.
Okay.
My lord, para 2, my lord.
Okay.
I read, my lord. At the time of consideration of the case of government servant for promotion, details of government servant in the consideration zone for promotion falling under the following category should be specifically brought to the notice of the departmental committee. Here, my lord, it's the selection. 1. Government service under suspension. 2. Government service in respect of whom a charge sheet has been issued and the disciplinary proceedings are pending. 3. Government service in respect of whom prosecution from criminal charge is pending. My lord, either of the 3 parameters is not surviving as far as the petitioner is concerned.
Why?
Because I have not suspended and suspension was annulled, my lord.
What about 3?
Government service whom prosecution criminal charges that Guwahati High Court stayed the criminal proceeding, and ultimately from the counter affidavit page 3 I read, my lord, that only it has taken effect in the December only, my lord. From that the counter affidavit, my lord, 3rd December 18, cognizance has been taken. Earlier I have cited a DOPT specific guideline. The criminal case is to be taken cognizance not on the date of filing charge sheet, but on the date of taking cognizance of the criminal proceeding. The letter already is met with my lord. Last date I submitted.
What is that?
It is in my lord's file. Otherwise, I can give you another copy also, madam.
Give a copy. Give me that copy.
I'm just in copy. My lord, this is para 8, my lord. Para 8, yeah, para 8. Elaborate policy letter I have already had it.
Paragraph 8.
Paragraph 8. This is a compendium of DOPT guidelines for all facets of disciplinary proceedings. They have recently issued on 23rd.
Okay.
My lord, then I'll take 2 minutes time, my lord. Page 24 of the counter affidavit. Para 3, my lord. Annexure 3 of the counter affidavit. The department has been receiving references seeking clarification on the grant of promotion in case of DBDPC with regard to the official.
At page Annexure 3,
Annexure 3, page 24, my lord.
the matter has been examined in consultation.
Yes, my
Ah.
that relevant, but legal, and it is further clarified in case of review DPC where a junior has been promoted on the recommendation of the original DPC, the official would be considered for promotion if he is clear from vigilance rank. On the date of promotion of the junior, even if the provision of para 2 of OM dated 1499 to get attracted on the date of actual promotion is considered.
Is this relevant?
It is not that much relevant, my lord. My lord, one thing I want to take to submit para 11 of the counter affidavit. Last 5 lines of the state pages, my lord. They say, as far as the relaxation part is concerned, my lord, in Border Roads Engineering Service Group A,
Where?
page 11 of the counter affidavit, my lord.
Page 11.
Yes, my
Paragraph.
last 5 lines I'm reading, my lord.
Okay. The
Down below.
In Border Roads Engineering.
Service profession period is applicable only an entry-level assistant executive engineer. And hence the relaxation given in para 2 of the said OM is applicable only for promotion from AEE to EE civil, as there is no further promotion period on being promoted EE civil and above. It is wrong, my lord. I will cite lot of recruitment promotion rules in this petition, starting from Additional Director General Border Roads, who is the next below
Okay,
rank.
let us hear him.
Last but not the least, my lord,
Hmm.
they are singing the bogey of that his command tenure has not been given because it is a sensitive post. My lord, in the rejoinder affidavit, I cited 11 cases of the
No, no, we'll not go to the facts for the time being. Here,
No, 11 cases where in violation of that.
whether your case was placed before the DPC.
No, my, that,
We are not DPC here.
a selection committee, yes,
We are not a selection committee here.
yes, ma'am.
What is our role in this writ petition is whether you had a right for consideration for the non-functional
upgradation.
upgradation on the date when your junior was
Sure.
considered.
Whether I was under cloud of. That-
Not whether considered.
Yes.
For that 2-3 aspects of the matters are there. Suppose you are a lodging of an FIR, it seems to a prosecution under clause 3. Then also there is a mandate that your case should be kept under seal cover.
Still cover.
So therefore we will ask the ASG whether they have decided not to give you, where is that decision?
And some records to be.
If not, we are not here to decide whether you are entitled or not. We can only interpret the rules
Yes,
and what is the policy of the union in this regard.
I bowed up.
Okay.
Yes.
So at best we can interpret whether you had a right of consideration on that date for the pendency. Admittedly, the FIR was lodged prior to you becoming, your case could have been considered.
Yes.
2013, your juniors were promoted in 2014. Even if we held that 1 year, you had more than 1 year of the qualifying service. So since your juniors were promoted, your case would have been considered. Number one. Number two, whether, now second question will be whether even if you are entitled, can be granted by view of the pendency of the criminal proceeding.
Yes.
This is the issue here.
Yes.
Yes.
Lordship, my friends, if I may take your lordship to the petition. Moment. So I have to assume lordship he has left behind all his prayers.
What was his prayers?
Uh,
Let us see once again.
Lordship, it's
Order
on
of
page
condemnation.
18.
Huh?
Page 18.
First sentence is page 42. Isn't it?
Yes, madam.
Annexure 6, page 42. What is page 42? These juniors were granted, isn't it?
Yes,
This is okay. He says whether juniors are given or not, since it's a notional, I am entitled.
Yes.
That's all.
1 for 40. Jitendra Prasad was my tutor.
Jitendra Prasad was junior. So even if we are granted non-functional, this will not affect Jitendra Kumar's promotion.
Yes,
This is your case. So you are giving up the first prayer.
yes.
Okay, then
Squashing not required because it is a financial upgrade. No promotion.
now
disturbance of
annexure
interest in
6, same annexure C, page 42. So only prayer remains is considered a petitioner for promotion for chief engineer by conducting review DPC.
That is granted by my.
Now where is the functional? Prayer for functional. Where is the prayer for functional?
Paragraph 3, prayer 3.
Prayer 3 is the subject matter of another writ petition where he was asked to consider his case under DPC, it will cover.
If he was eligible.
Eligible. Now he wants this also to be considered non-functional.
I want only one pair, my lord. That is granting. This is setting aside for DPS penalization and grant of non-functional upgradation SAG.
Where is that prayer?
1 point.
Huh?
That is on the attack with Roman 3, my lord. Last time.
By doing by conduct promotion. This is promotion, not non-function.
No, my lord. Page 19, my.
He ought to have segregated.
Last 4 lines. my
Okay,
lord.
grant
Last
and grant. Okay,
Yes.
okay.
Because review part has already, my lord, dealt with.
Okay.
Earlier 2 cases clapped
Okay.
together, now by part.
Okay.
Now, Lordship has seen
There is no order of rejection
of his.
of his non-function.
Lordship, that administrative order can always be passed at all. If he,
No,
your lordship will
see, two aspects of this method. Consideration, there is always a right for
yes,
consideration.
yes,
Promotion is not a right or upgradation is not a right, but it is a right for consideration.
for being considered.
And you are having a right to reject his consideration. Was there any order to reject his case that we are rejecting for this reason?
As of
You don't have. So let us record his case. What is his case? On the basis of his case, he will file a representation. You consider. We cannot determine.
My lord, representation is, I have already attached with my
Because he has-
petition.
he has come before this court for interpretation. We
Uh,
have not touched it.
You have not. So you pass an order so that we know your reason and
Yes,
then we
yes.
can decide.
Yes, 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 absolutely.
My lord, this is a representation
This was-
already.
Yes,
Yes,
Mr.
yes.
That's what you say. That at best that we can do. We'll record your arguments. Isn't that it?
My lord, I
We
have.
cannot decide sitting as a DPC that you are entitled. We
Yes,
can
ma'am.
only record what is your arguments and what are the DOPT you are relying on. They will consider all the aspects.
Based on whatever he has argued before the court, lordship is not.
Record that.
We'll pass. a
Yes,
speaking
Mr. Das.
My lord, my.
No, tell us and your answer. Suppose there is no representation also, you will
My
file
lord,
it.
I have represented page 40.
Okay, fine.
for
You have,
document.
you have.
That is remain unanswered so far.
So what is your proposition? Do you say that?
I leave it to my lord on.
No, no, don't leave it to what is your prayer. We cannot decide whether you are entitled or not entitled. Because for determination, there the memorandum you are relying on itself prescribes for a committee to decide.
But the committee's decision cannot be cryptic,
That
cannot be
be.
mechanical.
But where is
And
the
that is
decision?
why
No, no, no.
Lanet ASU.
Where is the
can be
decision?
challenged.
Yes, that is why Lanet ASU was asked to put on the record what the decision has been deliberated.
Not deliberated.
Yes, deliberated, my
Where
lord.
is that?
That is, they had to produce it. Justice Sanjay Mehdi, Honorable Justice Sanjay Mehdi directs it in the hearing.
They say
Please
there
put
is,
up the
we
record.
have not taken any decision.
Put up the record.
We have not
They have
taken
not
decision.
put up the records, my lord. Last hearing, they say I am with the record.
Hard.
Matter is pending, lordship. How can we take a
Mr.
decision?
PP Das, Learned Counsel.
My
for-
submission may please be.
Yes, yes,
advocate.
yes, yes, yes. Counsel for the petitioner.
My lord, one judgment of the Supreme Court also, J.C. Jadavka State of Haryana, where they have dealt upon the issue of relaxation. I am.
Oh.
I am.
You just listen what I am dictating, then we'll add everything.
This is a Supreme Court judgment. J.C. Jadavka State of Haryana on the matter of relaxation. Individual oblique in REM.
What rule you want to relax here? According to you, all rule are in your favor. They need to consider and give you.
My lord. Yes.
What rule you want to relax?
Yes, my lord.
According to you, all rules are in your favor.
Yes, my lord.
That is the lordship. I am not opening my mouth.
Yes.
Let me file a representation. We'll pass it.
Heard Mr. Das,
Speaking
Learned
of-
Counsel
The
for the petitioner.
representation already there, 48 pages.
Learned Counsel for the petitioner. Also heard Mr. R.K. Dev Chaudhary, Learned DSG. The present writ petition is filed assailing an order dated 28th of February 2019 within bracket Annexure 6 page 42. Annexure 6 page 42. Whereby, according to the petitioner, some junior persons junior to the petitioner were promoted. The further prayer in the writ petition is to consider the case of the petitioner for promotion from the post of superintending engineer civil to the chief engineer civil by conducting a review DPC for the DPC review DPC for panel year 2018/19 regular. Full stop. At the outset, Mr. Das submits that the other prayer was to grant non-functional financial upgradation to the petitioner with effect from 1st of April 2014 with all consequential benefit, inasmuch as, according to the petitioner, from the said date, his juniors were granted non-functional upgradation. Full stop. At the outset, Mr. Das has submitted that so far relating to the consideration of the case of the petitioner and conducting of review DPC has been is a subject matter of WPC.
WPC, my lord, review DPC is a 6292/20.
6292/2021, which is pending disposal.
Because my lord has passed the order, they have not complied with
Okay.
it.
Which is pending disposal in as much as
My
that-
lord has disposed of that.
okay, which was disposed of with a direction to consider the case of the petitioner and to keep the same under
seal cover.
seal cover. Full stop. Mr. Das further submits that the other prayer of setting aside of the promotion orders made in favor of the juniors are also being abandoned by the petitioner in the present writ petition, as the petitioner is claiming only non-functional upgradation, and grant of such non-functional upgradation will not in any way hamper the intercession. Full stop. The basic grievance of the petitioner is that the petitioner became entitled for non-functional upgradation and payment of higher scales of pay equivalent to a chief engineer of the department. Full stop. According to the petitioner, the required qualification for grant of such non-functional upgradation is the requirement of basic qualification of having service of how many years as SC?
4 years plus 2 years. Out of 4 years, 2 years to be command.
Okay, 4 years of service as superintending engineer, and out of which 2 years should be of command posting. Full stop. According to the petitioner, he is having 4 years, 3.5 years of posting as
No, my lord. 1 year, 6 months, 25 days command.
no, total 3.5 years as SC, 1.5 is in command, is that it?
Still he is an SC.
Huh? No,
He is
SC.
an SC.
No, at that point of time.
At that point of time, yes, lord. He joined as a SC, my lord, to 26/8/11.
No, we understand.
26/8/11.
When, according to the petitioner, when the case of junior to him for non-functional upgradation will considered on 1/4/2014, considered and granted on 1/4/2014, the petitioner was having 2 years of posting as SC and 1.5 years of posting as posting in command post. Isn't that it?
Yes.
In command post. Therefore, according to the counsel for petitioner, he was entitled for consideration for such promotion. Mr. Das further
Non-functional grant.
is non-functional upgradation,
Upgradation.
non-functional upgradation. Mr. Das further contends that where is that notification? 1.5 years.
Yes. That is the page 50 in my representation I have added, my lord. Page
No,
51.
that you have shown that it should be, it's page 50, page 50.
Page 51, last paragraph, my lord.
Relying on a office memorandum dated 25th of March 1996,
Yes.
issued by the Under Secretary of the Government of India, personnel, issued by Union of India. Mr. Das contended that the Union of India
Issued by DOPT will be better, my lord.
issued by the DOPT.
Yes.
Issued by the DOPT prescribed that when junior, when
Where, my
where
lord? Where
juniors who have completed their qualifying / eligibility services are being considered for promotion, their seniors would also be considered, provided they are not short of requisite qualification eligibility service by more than half of such qualifying eligibility service of 2 years. Or 2 years. Of 2 years or
2 years.
or 2 years.
Whichever is.
Whichever is less. Full stop. Full stop. Mr. Das contends that admittedly, his juniors were considered on 1/4/2014 and on 19/3/2013, the petitioner had command posting of 1 year 6 months, whereas the minimum requirement of command posting is 2 years, and therefore petitioner had more than half of the required qualification, and therefore his case ought to have been considered by the committee, by the selection committee. Full stop. The further case of the petitioner is that though the petitioner was arrested by the CBI on 20/03/2013, however, the cognizance was taken by the learned trial court in the case on
12/18.
3/12/2018. Therefore, there was no bar for the selection committee on the date when his juniors were considered for the non-functional upgradation, to consider the case of the petitioner. In this connection, Mr. Das relies on the office memorandum dated 24th of April 2009.
Judgments of Delhi High Court, my lord.
No judgment. That memorandum 1 to 3 page,
Yes, my lord.
page.
Page and the page, my lord. My lord, it is page 51, my lord.
No,
50.
page 51 is something.
50, my lord.
No, not 50. That serial number 1. I must have.
50, my lord. 42. Order of NFU.
It will come to page 35 of his rejoinder.
Somewhere that is page.
Page 35 of his rejoinder.
Relying on an office memorandum dated 14th of September 1992, read with that clarification. 1992. 1992. That explanation, that there was an explanation that it should be under page 37, I think.
There are 3 parameters there.
Page 37.
My lord, that is page 35, my lord, of my rejoinder. Page 35 of my rejoinder.
That's notified.
No, we have already seen, there is another
14
notification
September 1990.
you relied on where
That is lordship, your lordship will find petition, page 50. Yes, I talk. 11 portion, page 50.
51. Read with.
Perhaps this is
No, this is half year qualifying. This was a notification where this what is mean by prosecution for criminal charges was explained.
That is, my lord, I have given a copy.
separate bunch.
Separate
Ah,
bunch I have given you.
read with, read with office memorandum,
Date of cognizance.
office memorandum dated 14/9/92 and 2/11/2012 issued by DOPT to contend that even if the prosecution for a criminal charge is to be deemed to be instituted on the date on which the complaint or report of a police officer of which magistrate takes cognizance is made, and according to him, as the cognizance was taken in the month of December 2018, on the date of consideration of the case of the petitioner, there was no cognizance, and therefore there was no bar to consider this case for non-functional upgradation. Full stop. Accordingly, Mr. Das submits that the petitioner is having a right for consideration for non-functional upgradation. However, such right has been violated by respondent authorities, and his case is not even considered till date, though he had filed a representation before the competent authority on
That is on, my lord, that is, it is 20th March 19,
28th of March 90
which is still pending.
2019. Accordingly, he submits that a direction should be issued to the competent authorities to consider the case of the petitioner for non-functional upgradation as per extent norms and regulations. Full stop. Mr. Dev Chaudhary, learned counsel representing the Union of India, submits that the Union of India has filed an affidavit denying the contentions raised by the petition. However, Mr. Dev Chaudhary submits that the case of the petitioner was not placed for consideration, and therefore there is no specific order either accepting or denying his contention. That is the correct question.
Yes, otherwise, lordship, why we have not considered it?
That is there, but we decide? We are not an appellate authority. Full stop.
Lordship,
Ah.
lordship, at the opening paragraph, it has given qualification for being considered.
No, that's it according to him. We said according to him, according to the petition.
Because there is something.
No, we are not giving any findings. We are saying according to him. You consider. Full stop. Full stop. It is true that the respondent has denied the right to the petitioner by way of the affidavit. However, admittedly, the case of the petitioner has not been placed before the selection committee for upgradation of the for grant of non-functional upgradation. That being position, this court cannot sit as an selection committee to determine whether the petitioner is entitled for such non-functional upgradation, inasmuch as in a given case where a decision has been already made by the authorities after consideration, this court can very well look into such decision and or decision making process in exercise of its judicial review. However, this court is neither an appellate authority or a selection committee to determine the entitlement of the petitioner, inasmuch as such exercise is to be carried out by a selection committee prescribed under the extant norms. That being the position, this court is of the view that the petitioner is having a right to get considered his case for non-functional upgradation, inasmuch as it is well settled that the consideration for promotion is a valuable right, though right of promotion is not. Full stop. That being the position, the writ petition stands disposed of, directing the respondent authorities to consider the case of the petitioner for non-functional upgradation in terms of the extant norms, and consider his claim and pass a reasoned order in this regard. Such exercise be carried out within a period of 6 weeks from a receipt of the 8 weeks from the receipt of a certified copy to be produced by the petitioner before the respondent number. Yes.
Say, MOD, sir, my lord, the respondent number.
Respondent number.
One.
Respondent number 1. At this stage, Mr. Dev Chaudhary contends that even it is assumed that the petitioner's case is considered, however, in view of the criminal proceeding and in terms of the office memorandum, the case of the petitioner is required to be consideration of the case of the petitioner for non-functional upgradation is required to be kept under seal cover till the criminal trial is over. Full stop. This court will not observe anything in this regard. Whatever is necessary shall be done by the respondent authorities in terms of the extant norms and office memorandum issued by the DOPT. Full stop. A liberty is granted to the petitioner to file a fresh representation incorporating all his grievances if so advised. Otherwise, the authorities shall consider the representation of the petitioner filed on
My lord, it was on 19.
That was on 28/3/2000.
28/3/2009.
Nine.
That's all, you are at liberty. Suppose you think that yes, he is entitled, because there is a gray area here. Gray area is we are not going for the eligibility, but subsequent office memorandum, it has said that in terms of CCL's rules, CCS pension rules, there is a gray area that you will have to, whether it should be seal cover or not. That's why I have concluded and added that argument.
Lordship, just one point of
Yes.
clarity. Lordship has indicated
What's your selection?
our staff.
Hmm.
Since he is not eligible, therefore it was not put.
You are not to decide eligibility. Eligibility is to be decided by the selection committee. He will say, okay, he is not entitled. With the similar juniors are given, who will decide that? Admittedly, he is an officer. His juniors are given. You can reject him. Those juniors are granted because you will have to answer those issues. Whether he is why he is not eligible according to you?
He is on the qualifying service.
Huh?
Qualifying service is something more than what he said.
Hmm.
There can be a relaxation of the qualifying service.
Hmm.
There cannot be a relaxation of the command tenure. So, since he did not have the command tenure, we have not put it up for the screening. Now,
Then you give the reason. There is no
that-
reason for you so that we can make a determination.
Command
That
tenure
what-
is a part of RNP rule.
no, that is why what I was
Okay,
I was
okay,
trying to
you
say-
decide it, then it will be
We will dispose of his representation first.
first. Okay, you will decide it, then instead of going to committee, he'll come back to us,
Yes,
we'll then
reason
clarify
not.
everything.
Reason
We'll-
not.
Only that, only that.
Not
Okay.
cryptic order, ma'am.
Huh?
With recent order.
With reason, speaking order.
Speaking
Yeah,
of-
We'll write it
order.
as speaking order.
Yes, my lord. has-
Therefore, we said you write a phrase, give a pointed
file a
point,
press
then let them answer.
incorporating everything.
Everything.
Let him file a
Yes.
press.
Okay. Who will be respondent number?
One.
What respondent number? Okay. In view of the order passed in so and so, IA 1268/2022 stands closed. Mr. Das,
Deeply obliged, my
you
lord.
will get this copy uploaded only on Monday,
Deeply obliged.
not before that.
It is my 24th appearance, my lord, in this court. I feel pleasure, my lord. I have learnt a lot of this court. In Delhi, what happens, my lord? For a 6 months, 8 months period for service matters, it did be better different. So, advocates, especially newcomers, they do not get a chance to learn. Here, we get a chance to know the minds of learned judges and prepare
Sir,
ourselves.
this judge
Nobody-
expresses his mind, that is the problem.
Yes, that is the beauty of this court. I belong to Assam and I have got a soft corner for this. Only for ethical value I am coming.
So he is coming again.
No, my lord, only for ethical value I am coming, not for any other purpose.
Okay.
Honestly speaking, I am deeply bowed down and obliged.
Yes, Mr. Das, what is this?
Lordship, I have gone through the record. In fact, Lordship, the notice which has been produced before Lordship, that in fact favors me. That corrigendum, Lordship, was issued on, Lordship.
Flag mark
Yes,
can give.
yes, that flag mark
Yeah.
that has been shown, Lordship, 14/6/2018.
Mm.
So that means, Lordship, that list was already finalized.
14/6/2008.
But he is speaking about other case. It is not my lord, because you
No,
know,
no, just tell us, let us understand when the selection started. We'll go details. There is no problem on that. When was the selection advertisement was issued?
Lordship, the advertisement was issued, Lordship, on
19/5/18.
19/5/2018.
19/5/2018. Okay, advertisement.
Yes.
Now selection. When was the interview?
Interview, Lordship, call letter was issued on 23/10/2018.
20.
23/10/2018.
Then select list
And select list was published on 9/7/2009.
972019. You were placed at
I was placed at serial number, serial number 12.
serial number 12. Is it a common list or it is a lot wise?
It's a common list of all the selected categories.
Now what
Lot wise.
in your
Lot wise,
lot wise different villages.
different villages.
Now in your village you were selected.
Lot.
What is your name?
My name is Nurul Islam Ahmed.
Okay. Nurul Islam Ahmed. Okay. You were according to selected on 9/7/2019.
19.
When the corrigendum to select list was issued?
same day.
Same day. Same day, all along, they were submitting the
Same day.
same day,
Which date? 9/7/2019
2009.
corrigendum. Now what is the name?
Nurul Islam Sheikh, son of Gogon Bepari. My father's name was
Nurul
different.
Islam
Sheikh.
Sheikh.
Yes.
You are Ahmed, he is Sheikh. His father name is Gogon
Gogon Bepari.
Bepari. And what is your father's name?
My father's name is Abdul Aziz SK.
Abdul.
Aziz SK.
So SK, his SK is your father's. Okay, Abdul
Aziz SK.
Aziz SK. Okay. Now it was issued. Now what is your grievance?
Lordship, my grievance is that, Lordship, initially I was selected.
Selected. This
And-
person was not
Yes,
selected.
so
What are the
after-
marks given by the
after-
individual
after-
candidate?
After publication of the select list, Lordship, there is some huge anomalies, Lordship. They have collected huge amount, 5 square flags from each of the candidates.
Mm.
And Lordship, in individual case, there are some stay order. And subsequent, and now from the record I have seen, there are 4 members of the selection committee.
Mm.
Now it has been found that only 3 members have given their names.
Mm.
Marks.
Mm.
And 1 member is missing. They have already said in their certificate, there are 4 members in the selection committee. Only 3 members have given the marks. That is another illegal thing. It has come to my knowledge only after presenting the record. And in this record, you will log that this is a neatly typed copy of the marks, and there is no date. You will not find any date in that mark. Select. That this is
Matlab,
only a
petitioner-
compilation sheet.
Where is the petitioner's number?
Matlab, lot of will find flag, matlab,
Yes, given some flag.
Flag 8.
the first flag, lot of will find the mark, first and second position has been shown. One has secured matlab, 30 marks, other has secured 33.
Okay, now tell us,
The individual marks, the second flag, lot of will find the individual marks. Matlab, they go by the father's name. Matlab.
Hmm.
One is Nurul Islam Sheikh, father is Dogon Bakari. And this third flag, lot of will find Nurul Islam Ahmed, father is some Nurul, father is active.
okay. Okay,
Matlab,
it's fine. Okay, now tell us, what is the reason of that? Where is the selection committee formulation?
Yes, your will also find a page.
Okay, we'll come to this later on.
Yes.
Now, where is the reason for that there is a mistake? So therefore, let us.
Matlab, in fact, matlab, because of some subsequent case revision, the records are being seized by the inspector of CM Special Vigilance Cell.
Hmm.
Matlab, from them, we have received the records.
That we have seen somebody's certificate, the
Certificate.
inspector certificate.
In fact, that also is certified copy.
Pritam Shaikh, yeah, inspector of
Those
police.
are there. Well, here I don't find. In fact, on 9/7/2019 is the list published. 9/7/2019 note I don't see. But the thing is, Lottie may kindly consider petitioner cannot approbate and reprobate at the same. Well, his case is that, well, kindly come to his prayer in page 8. He is indicating some illegality in the process. At the same breath, well, he is claiming that he should be
Where is the
appointed.
prayer?
Page 8.
Page 8.
Well, a writ in the nature of a writ in the nature of certiorari shall not be issued to set aside and quash the impugned recommendation made by the corrigendum dated 9/7/2019 by replacing the name of the petitioner with Raspura number 7 as regular Gaugura of lot number 12. Next is
Now, what is the government's decision if you say that there are who lost the affair?
FIR has been lodged against the entire selection process and some charge sheet has been
So
filed
under the same deputy commissioner.
under the same deputy commissioner.
Now, what is the stand of the government that these some are having leaked
Well,
because it is still under investigation?
Well, no, charge sheet has been filed.
Charge sheet has been laid.
I have the copy. But I will
What
not.
is the where is the charge sheet?
I have a copy. I have
In fact, lots of search sheet.
One by one.
Petition-
Let us
petition-
understand what is what.
lot of.
Only 4 matters are left. We have time till 4:30, and
I-
out of
I-
4, 3 will be adjourned.
Yes, sir. I have the copy of the chart. But petitioner cannot go to that extent because he is
No, petitioner cannot go to
Look,
that extent.
yes,
That is
Look,
understood.
look.
But we want to know what is the stand of the government. If government says that this whole process is corrupt, if government says,
Look.
can government come and say, no, appoint this is having sanctity?
no. In fact,
All are
out of 70,
All
out
are
of 70,
All are
out of
appointed except
70,
this one.
out of 70, only this
All are-
petitioner left.
No,
All are okay.
there is another writ petition lawsuit pending, wherein also there is a stay that is also filed by the same.
No, we'll go.
Even that
We want to
process
know. We want see if there is a mark. They have got highest mark. They have issued corrigendum.
Look.
Well and good.
Look.
Okay. In a general case, we will say that fine. How can we sit over until and unless you say that these are fake, these are not that. So far, coming to the 4 select committee members, That suppose quorum is there, one did not participate, three participated, they given the mark.
my lord,
Okay, fine, that also will not
my
interfere.
lord, all three.
But question here is, what is the stand of the government as regard the sanctity of the selection process that will record?
I'll take your lordship to the, just I have indicated the prayer made in the writ petition, my lord.
Hmm.
On the basis of the mark secured by the petitioner, in the qualifying exam, he has prayed for his selection.
Hmm.
The second prayer I'm just reading.
No, that understand. That
But
is that we
then-
can pass an order in 5 minutes.
Then-
That this is the prayer. We have perused the record. He has got
Then-
so and so
Then,
marks.
my lord,
Therefore, they were within their right to issue a corrigendum. There may not be any office note, but apparently there is no illegality. Writ petition
my lord,
stands dismissed.
then, my lord, his representation.
5 lines,
his,
not
his,
more than that.
his representation file is developed page annexure 9.
Now we want to know,
Look.
because since the senior government advocate is here, we
Look.
want to know the stand of the government, because admittedly this is on record that there was allegation of anomalies in whole district.
Look.
The person, deputy commissioner, who is the chairman of the select committee, was arrested. Then there is a search. In that backdrop, what one of the highest officer of the legal officer of the government makes a submission, will record it while dismissing this writ petition.
As on today, my instruction is that the selection process has not been started. It has not been. In fact, the persons have been appointed. They have been appointed. They are working.
Okay. Where is the government's affidavit? Where is the government's affidavit?
Respondent number 1 has filed an affidavit.
Who is
On-
respondent number 1?
Lordship one, Dilip Kumar Das has filed an affidavit.
Who is he?
He is the Secretary to the Government of Assam, Revenue and Disaster Management Department. Lordship, in paragraph 7, may I point out? Earlier, Lordship, in my writ petition, Lordship, I have made a statement, Lordship, that they are contented to file a miscase for vacating the interim stay order. And Lordship, in this case, the respondent number 1 has made a submission in the affidavit, Lordship, that it is that respondents are contemplating to file a miscellaneous case before the Honorable High Court seeking leave to appoint a person in some sort of elected office is not true. But subsequently they filed. They filed the Lordship miscase and Lordship that interim stay order was vacated. And that was filed by the deputy commissioner, not by the government.
Where is the affidavit by deputy commissioner?
Deputy commissioner's affidavit is not there.
Deputy commissioner has not filed.
The respondent number 2 has filed the affidavit.
Who is Nurul Islam Ahmed?
Nurul
Resign that.
is the petition. Is the petition.
Who filed affidavit here? That revenue.
The revenue
They have
and,
no role.
and the respondent number 2 has filed.
Respondent, who is respondent number two?
Respondent of Commissioner Lower. Before them, the representation has been filed by the people.
Where is the earlier stay vacating order? Anything? Any order?
Not getting stay.
Hmm.
Then my lord,
That is-
honorable court says, then no, 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 go to-
No, in some other cases,
Some
stays-
other
other
case,
case,
that we want.
the group.
In your case, IA is still pending.
Court says, then no, no, I'll see the mark, then we'll decide. it.
Okay,
How-
we'll decide. We'll decide today itself.
And my
Yes.
lord,
IA has been dismissed. Lord.
Okay. Now give us the IA stay vacation in other cases. Any writ petition disposed of?
No, I have filed 3 individual writ petitions, or the 2 are still pending. Other-
The other case, there
Individual-
we are objecting that they are claiming for regularization, they are self-filed down. That is a separate issue. Here
That
is
is a
election.
separate
process.
That is separate. In
That
fact,
is
in
separate.
some,
And
in case
that
of Gwalpara,
Yes.
this court has passed an interim
Yes.
order so far relating Gwalpara because there was a selection.
Yes.
So far relating to Dhubri, we did not pass any interim order because this was self by appointed by the villagers. That we did not pass.
honorary
it.
gaon board.
Honorary
Well,
government.
their deselected persons are respondent.
Lord, the
Malad,
entire illegality is
Our urgency is Malad, because of Basundhara.
Now, how you answer that there are illegalities? So go to the land because that can be, they have
South
taken a
Salmara
stand.
Mankasar.
Huh?
Only in respect of South Salmara Mankasar, Lord, this entire illegality has taken.
No, understand
Okay.
that there is an illegality. The respondent number 2 has taken a stand that see any illegality or whatsoever in respect of the appointment, you can come to the appellate.
But there is absolutely no bar, Lord. I have the
Like even
In my,
Since
I
they-
did my lord, if
because
you
this is a
told
unique
my
case.
lord,
No, we will not go to the search for a timing. Give
No,
me
you
the
can-
any order of vacating the stick. Let us see.
my lord, that is in this case, my lord.
Maybe just I want a copy.
Sorry, my lord, the affidavit no good.
filed by R7.
Uh-huh.
Affidavit.
This
filed
is
by the-
available on record.
My lord.
Where? Yes.
99.
For going ahead with record here.
Same select list 9/7/2019.
9719.
But that is pertaining to Lordship that those honorary Gamparas, they sought automatic regularization.
In that, my lord, ban was
Ban was in. Automatic
that-
regularization cannot be given. Lord.
ultimately, my lord.
Ultimately,
They
court has
claimed that they are honorary
allowed us to
Gamparas.
proceed further.
And but Lordship, although at the same time they said that where there are individual grievances, the court makes it clear, last line Lordship, that if any interim is operating against any individual of the aforesaid select list in other writ petitions, the cases of those candidates should not be taken up separately until further clarification granted by. So by this also order also the court has given us that liberty. Those individual writ petitions were not touched. Only those writ petitions Lordship where the
Just a minute. Just. What you want to show, Mr. Mohanto?
That's it.
Hmm.
Okay, your lordship has granted the order.
I have considered.
But it's clear, my lord, that is.
That liberty was granted, then they proceeded with the selection. Then they participate. It is subsequent to. Those were the, there is a
They are the
persons,
self-styled Gaon Bura, my lord.
Kavuras who wanted us, that
Regular,
we should be regular, so process was stalled.
Fraud.
Then there was this application stay was vacated, then it was proceeded. Now he comes that there was illegalities.
No, yes, he's select.
His selection, he says
my name was
illegal.
initially appeared. No.
Yes, what is the search sheet? That's I have.
Our seat, my lord, there is nothing, my lord, against him, lot number 12, my lord. If against other plots, my lord, there is some application is made, but nothing, my lord, in your lordship, kindly para 17.11 and
I have given this certified copy. Yeah.
Yes.
page 168 also, my lord, your lordship will have a record of.
Yes.
There are affidavit is annexed.
And next,
Yes, in affidavit, my lord, they have.
In my rejoinder affidavit, only part of, because there are two certificates. One is filed against the Cyber Rahman. We have obtained the certificate copy of the certificate filed against B. Vikramaditya Bora and Lordship A.K. alias.
In fact,
Wait a minute.
Vikramaditya Bora has given same marks to both the parties. In the record, I have seen.
okay. Yes, what you want to add?
How can Lordship? He cannot just claim benefit of
Your Lordship,
in one hand.
We have understood what are the issues properly now. You are.
Lordship wanted to see the notice. What was the decision? Hence the corridor, that between issuance of corridor. And Lordship from the notice it has been reflected. That was there's no any corridor in on 2019 when this like this was up. And in terms of the Lordship, certificate file in the CM Zealand case, they have also taken action. Your Lordship will find one order at page 100.
Page 100. Page 100 of the.
Or Lordship will kindly.
Okay, I'm at page 100.
Yes. Page. The original one is at page 100. In persons of the letter so and so, received from the superintendent of
Just a
police.
minute, just a minute. Page 100. Okay. What is this?
In persons of the letter number so and so, received from the superintendent of police and special vigilance cell, Guwahati, the below mentioned Gaon Bora have been arrested by vigilance PS case number so and so, amendment, and detained in judicial custody on 28. And this by Deputy Commissioner. Now, these 4 Gaon Boras in terms of the certain filing that have been suspended.
Who is he?
Deputy Commissioner.
No. Who is this arrested? What is the relevance of this?
Same from the same that those who were appointed.
Yes, my lord, my lord, in fact, my lord, I have an answer to that, my lord.
No, just take your seat. Let him hear. So you say that in a law there was a Gaon Bura was arrested.
Yes.
And he was appointed from the same select list.
Lord.
This is your case.
Yes, four persons have been arrested and they have been placed on the and by the Deputy Commissioner. South Salmara Master.
Where is that list you have produced? Okay.
Lordship, that this has been produced, there is no date. There is no date. It has been done subsequently, neatly type out copy of all printing.
It was seized by
And Lordship, in the Lordship, that's it. There are some manipulations, they are overwriting.
in that.
Those are recorded in the certificate by the investigation of.
In that case, you should have fill in for cancellation of the entire selection, not for appointment.
That is pending in another writ petition. So the entire selection is also under select
Just a minute.
by another.
Okay, we'll come back.
Regarding that, that 2 o'clock, my lord, by foot number 1 will be sitting, I'll be there, my lord. Regarding that 4 persons, my lord. He says that these are spent that they are dismissed from service. No, my lord. They are temporarily arrested and thereafter they are instated, they are in service, my lord. This is the just 4 persons. Because some individual allegation was made against them, my lord, but immediately they were these 4 persons.
We'll just want to hear, Mr. Nath and to assist us.
Sure.
Assist us. Where these 3 persons who are member of the selection committee after investigation are said to have taken prima facie. Charge sheet is not a gospel
Right.
truth. Prima facie saying that these 3 members, Vikramaditya Bora, Saifur Rahman and Atika Sultana, taken 5 to 12 lakhs bribe and manipulated the entire selection. That is on record in affidavit and in a search sheet.
But in search sheet in aspect of lot number 12, my lord, there is no. Your lot individual elections are there in the search sheet. But lot
That's
number
why,
12, not a single
that's
line.
why. That is where, how in the such a circumstances, what should be the proper course of action for a writ court? Forget about him for the time being.
Sure.
Forget about him for the time being. To dismiss his case, very good grounds are there.
Sure.
Will not even look into, will simply say that marks are there available. But will it amount to giving a certificate to this mark by a writ court? How do you answer it? Will it be a certificate after a search sheet? That entire selection process was manipulated. And if we were to hold that all marks are good, how the trial court will do?
Well,
Enlighten us.
right.
This is, we are to dismiss his petition on a selection in a judicial review, nothing. But how we deal with this? Give enlighten us today? Tomorrow is a Friday. Tomorrow is a Friday. Tomorrow is a difficult process. Just help us. I am saying not as an adversarial litigation.
True,
We'll have
true.
to make a comment
What is the
that there is no problem in this lot. How can we take a call? There is a search sheet. You help us. See, first line in brief of the case is that complaint Rahul Amin 20 address submitted so. Then all this. Further investigation found that during their so Atika Sultana, SCS posted so, all these persons are specifically said they were involved in this cases. They are accused. Now they are the members of the select list. They have given marks. Now I'll have to certify this select list to be correct.
I'll
See the predicament of this
Lot-
court. Mr. Mohanto.
yes.
Will
Lordship, if we
no, we understand your anxiety. We understand.
Others are working, only this, except this one. And my lord, what I'm more anxiety is that, my lord, if I get the job, my lord, after 9 months, I'll be.
No, we know that. That's why we fixed it today. But
Alright,
at the
Lord-
same time,
Lordship,
you will have to enlighten us. You are a senior counsel and Mr. Nath.
Lordship,
Because this will have a impact, might have an impact on
others.
the entire thing where CM's vigilance has initiated an investigation. You have instruction from your client.
Correct. Lordship, give you 1 day time.
Okay.
Today to
Okay, we difficult. Yeah, Monday.
Monday.
Okay. List this matter on Monday.
So Monday I will not be there. My lord.
Okay, no problem on it. We'll try. See, Mr. Monta, we are also in a situation. That's why I said to dismiss his petition, it will take 5 minutes, but we'll have to give that we have perused the select list. Marks are fine. We find no infirmity in the select list. Therefore, his petition is dismissed. Meaning thereby, Mr. Mohanta's client's selection is upheld.
The other related issues, so that has to be answered.
Okay, can it be on Tuesday?
Tuesday.
The record.
Yes, take back the records. Huh?
I'll-
Just
I'll-
think over it.
On the next day,
Think over it.
definitely.
We cannot, can we give a certification in this background?
If
Normal case, no problem.
If
on that.
Lordship
We'll see.
today passed an order, ultimately what will happen if
Yes, many people will, Mr. Mohanta will go and cross-examine. This is,
court has happened. I'll like on
Tuesday.
Tuesday.
Okay.
এইটো দি দিব লাগিব চাগে দেই।
এইটো লগাই দিব।
Okay, let us refresh it. 1183 appointed, isn't it? Just refresh.
1183 is the first.
Mm.
The first HCP comes to effect on 9/8.
Uh.
The benefits are to be granted on 12 years of the
So therefore, your entitlement would have been on 9/8/99. Okay.
9/8/99 is the date that the HCP came into force.
Mm.
Therefore, although I completed 12 years prior to 9/8,
On the date itself, you are entitled.
I will not be entitled on the actual date when I completed 12 years, but
But on the
of
date.
So I was entitled to 9/8.
Mm.
Now, prior to 9/8,
When you completed 12 years and
12 years, I will complete in 95. 195, I would have.
12 years,
195.
195
I
and
would-
24 years,
2007.
24 is not necessary for the first point. So you have interest scheme is itself is at 9/8/99. So
So I
on
did-
that date, 12 years should be counted from that date, backdated. Okay.
Now 9/8/99, when I was supposed to get the first benefit,
Mm.
I got a punishment on 27/4/19.
Punishment
27/4/19.
27/4/19.
Stoppage of money for 1 year without giving it.
Stoppage of 1 increment. Without cumulative effect.
Without
Okay.
person who joined on the first of who joined prior to 30th of June of any particular year,
Mm.
their increment comes on the first day of that.
Mm.
Those who joined after 30th of June, their increment comes on the 1st of July.
July.
So now my increment would have come on 1st of January 2000 for that year. For the year of 2000, my increment would have been on 2000. They stopped the increment in 1999. Therefore, the punishment ended on 1/1/2000. I did not get that increment.
Mm.
Now, the moment my punishment ends, is the day I am fit for promotion. So, my argument is, my first SCP will be from 1/1/2000.
According to you, punishment will be completed when? On 1st of January 2000. Mm.
I don't get that increment.
So punishment for stoppage of 1 year increment. So 1 year increment, your next increment is due on
1/1/2000.
2000.
So that day my
But
punishment.
your earlier increment was when?
That was in 1/1/1999. I got that already.
You got that. So what is the effect of the promotion?
27/4/99. If they say I will not get it for 1 year, that means whatever I had to get on 1/1/2000, I will not get.
Mm.
I will next get it on 1/1/2001.
2001. Okay.
So my punishment will end on 1/1/2001,
2001.
not 2000, because
Okay.
I did not get that increment.
Uh.
The moment I don't get that increment on
Okay.
1/1/2000, my punishment ends.
Over. Okay. Okay.
For the next year, I will get it in 1/1/2001.
1.
So 1/1/2000, my argument is my punishment ends.
Mm.
I should get my ACP on 1/1/2000 or 2/1/2000.
Mm.
The moment my punishment ends. Respondent's argument is it will, what has fallen from logic, it will go to 1/1/2001, and therefore it should come on 2/1/2001. That
So
1 year
according
gap
to
is-
them, so 2499 from 1 year will be 27/4/2000.
2000.
So then also your increment is due on 1st of that increment you will miss.
I'll miss that in any case. So, but my punishment has ended on 1/1/2000 when they did not give it to me. The day I missed it, my punishment is over.
Your next increment, even you will not get on 27/4/2000, you will get in
1/1/2001.
1/2001.
So that 1 year is now in question. They have said it should be
I would get delayed by 1 year, 4 months, 23 days. My argument is it is 4 months.
That is
and
the
23
only
days.
issue.
That is one issue. Now, next month, when they calculate this, they correctly give it to me, Lordship will find at if Lordship has my argument.
Yes.
Lordship will find point number 6. That is where I have.
So far relating to calculation, punishment and fast.
That
Okay.
is- Now, point number 7, Lordship will see on 7/8/2006. Hyderabad correctly gave me my second receipt from 1/1/2007 because I completed 24 years of service on 1/1/2007.
Okay.
Hyderabad gave it correctly. Now they did not give me the now those two SPs are gone. In the meantime, MSCP comes into. MSCP came into play on
2008.
1/9/2008. In 1/9/2008, I should have got my now the calculation for my third SCP comes from the date I was appointed. Now, when this comes into play, 13 day considered. Lordship will find
No, they have given you when the first
They-
was given to you.
2001.
they gave it 2/1/2001. I want it for 2/1/2001.
Granted to 1/2001.
They have given
According to you,
it should be 2/1/2000. Hey, here and there, my lord. will
Okay,
happen
so
after the
this is
different
one.
kind of thing.
then
My lord, my second SCP, Hyderabad gave it correctly to me on 1/1/2007.
2007.
They say will belated at para number 10. I'm sorry, my lord. They now say in 2013 that no, we will refix it.
So this is under chale.
That-
Refixation is under
That
chale.
is under
What is the ground of refixation?
round of
Then recovery also there.
recovery. has been made. If the fixation would have been made, my recovery would have
Okay.
been there. I have
So
returned
what
it.
is the reason for refixation?
That has been given. That was fine.
It's so simple. Last that we were a little bit confused. That's why I said have this.
Now they say at page 7 of their
Subject to Pegu not complicating the answer.
now they in their annexure.
What is the reason for? They said that in 2013 we recalculate because you were wrongly given on 1st of
January 2007.
January 2007.
That is
Somebody give you 1st of 2007. According to them, there was a mistake.
Yes.
So we'll recalculate. What is the reason? What is the
That
mistake?
dispute arose when the issue of third MSCP came up.
Okay.
So that review has been done.
at page 33. They say there is a table of people find that serial number 43 is binding.
Page 33.
Para 43. Column 43. Application of which the running page would be 33.
Running page is 33 and Annexure 6. Translated version.
33. Of our edition, our affidavit in opposition. Madam.
Your affidavit in opposition
Hello.
by Nemhas Tirki.
Yes. Hello. At page 33.
So running page will be
65.
68.
68.
No, 65. You are correct. The running page will be 67, 33.
33.
Hirendranath Malakar.
Serial number 43.
Now Lordship will find.
Serial number 43. You are Hirendranath.
Yes, yes.
Okay, what is your
Now
case?
1, 2, 3, 4, the 7th column Lordship will find.
Hirendranath Malakar.
31/12/92 they said 10 years.
Okay, 31/12/94 to 31/2006, 24 years.
Then they say he was eligible for second financial upgradation under MSCP scheme with with effect from 18/4/2009.
So according to them, 2 years to why 18/4/2009?
But it was granted. Now Lordship will find
Why the reason?
that is also there. That is also there.
Yes, Mr. Chakraborty. Anything urgent? Okay, wait. He has a scope to dismiss it for default.
Lordship will have their counter affidavit page 27.
Page 27.
Para
Their counter affidavit Nimhans Turkey,
yes,
paragraph 2.
paragraph.
I am fully conversant. That
No, it is
before
in
awarding the
this
Paras reply response, like to briefly for petitioner appointed on 1/1.
In this regard, Lordship have you checked it? It is signed by one deputy commandant. A letter dated 24 April 2000.
Commandant, it is commandant.
Deputy commandant. 2 pages later.
So if this affidavit is filed by on behalf of respondents
Yes.
by Nemhans Turkey, son of PM Turkey.
Yes,
Isn't it? It starts at page 35.
right.
Now which paragraph?
No, but I was referring to the annex.
Annexes.
Annex.
Okay.
Internal page is 27 of it.
Okay, just a minute. 27.
Okay.
27, page 61. Yes, what is this?
My
Deputy
lord, here
commandant.
The deputy commandant says regarding my MSCP regarding para 2.
Hmm.
In this regard, it is to inform that Head Constable Richard Malakar was appointed on CISF on 1/1/18. After completion of 12 years of service, the first ACP was reviewed him on 9/8/99. But he was provided benefits of ACP with 26/11/2001 means after 2 years, 3 months, and 17 days. As per MSCP scheme, his second benefit is due on 18/4/2009.
So they are counting it from 26/11/2001.
Because that is the day when the
Got it.
the TCP
Understand?
the DSCP had set.
So your whole thing will be based when you are entitled for the first MSCP. Moment we suppose we hold that your punishment was over on such and such date, therefore you are
Then
entitled for this date, then thereafter it will that 7 will be correct and therefore no recovery. This is the case.
That is fine. The
So
date when the
whole
punishment is-
thing depends upon the first determinant.
First day, when I should have got my that will let the entitlement. This is the date of my entitlement. Either it is
Because
2000 or 2000.
because he was paid 2 years later, but third was paid 2 years prior. The third was counted on the basis of 20 years from the date of your initial entry. So therefore 2 years was less. Now they say no,
It will go
you got your first on 2000 or to have got on 2001. So
Yes.
therefore it should be not 2007, it should be 2009. That is the case.
That 1 year currency of punishment, that part. Because-
Is it that case? That will come to whether that what should be the currency. This is the case
Ma'am.
because of the currency of punishment, he could not have been given MSCP. Therefore, it was delayed. And since it was delayed, his second or third whatsoever, first, there is no issue as regard first. At 99, there is no issue. So far relating to second, due to currency of punishment, it was delayed to 2001. So since it was delayed, it should have been 2009, but he has by wrong calculation was given from 2007, and therefore, therefore, you want to have a calculation, and if necessary, want to recover. This is the case. Now, whole issue is what should be a currency of a punishment. That's all. Why we're so confused on last occasion?
So there was another aspect, my lord,
Uh.
because initially he got the benefit of two SCPs, first and second. So when that third
He was entitled.
entitled for MSCP, that MSCP scheme was with effect from 1/8/2008.
Okay.
1/9/2008. So prior to that period of 4 months, 1 year punishment and four months, that has been calculated. Whether the 1 year should be calculated? Because if
Now, what is your argument regarding your argument is clear? Okay. I just will dictate something. We'll correct it just to remember. Just will record nobody's case. The grievance of the petitioner is as raised in the instant writ petition. As regards non-grant of benefit of third financial upgradation. Third financial upgradation to the petitioner in accordance with modified assured career progression scheme, inasmuch as, according to the petitioner, he had completed 30 years of continuous service in Central Industrial Security Force on 1/1/2013, when according to the petitioner, he was entitled to be granted the third financial upgradation. Full stop. Okay. The petitioner, Mr. Pegu, just any mistake, or if you dispute anything, just tell us immediately. Yeah? Just will then correct. We'll definitely submit your record your submission. He's also will record a little bit later on. We'll just record some undisputed facts. Okay. The petitioner joined the service under CISF on 1/1/1983. Full stop. The assured career progression scheme was given effect to on 9/8/1989. Hereinafter referred to as ACPS. Okay, bracket close. ACPS 1999. ACPS 1999. Okay. In terms of ACPS 1999, the employees will granted financial upgradation to the next higher grade pay, subject grade pay, when an employee completed 12 years of service. Full stop. The second benefit is granted after completion of 24 years of regular service. Correct? The petitioner completed 12 years of regular service on 1/1/1995. Correct? 1/1/1995. However, as the scheme itself was introduced with effect from 9/8/1999, the petitioner was entitled for first financial upgradation with effect from 9/8/1999. However, the petitioner was granted financial upgradation under the SCPS 1999 with effect from 2/1/2001.
Originally, they gave it to me from 26/11/2000. The date when the promotional committee set.
Thereafter,
Later in 2014, after I filed the writ petition, they corrected it to 2/1.
and that has been given.
The 2/1
Will not go to, will not go to that, will not confuse me. Was granted with effect from 2/1/2001. It is the case of the respondent that he was not granted such benefit with effect from 9/8/1999 for the reason of currency of an punishment. Correct? It is important to note that the petitioner was imposed with a punishment of stoppage of 1 increment without cumulative effect, with effect from 27/4/1999. 27/4/1999. Full stop. It is the case of the petitioner that as the punishment was without punishment was stoppage of 1 increment without cumulative effect, such currency of punishment shall be over on 1/1/2000. Mr. Mojumdar contends that as the petitioner joined in the service on 1st of January 1983, his increment shall be due on 1st of July.
January.
1st of January of the year. The increment is due. Full stop. On the first day of the year. On the first day of the year. First day of the year. According to Mr. Mojumdar, as the punishment was imposed on 27/4/1999 with a stoppage with 99 of stoppage of 1 increment without cumulative effect, the petitioner shall not be entitled for the next increment which was due on 1st of January 2000. And accordingly, the currency of punishment will be over on 1st of January 2000 on deprivation of the petitioner from such increment. That being the position, according to Mr. Mojumdar, he will be entitled for the next increment on
2/1/2000.
2/1/2000. 2/1/2000. But increment is what? When will be your next increment due?
2001. When I complete my 2000 years, entire year when I complete it, then for the next year, it is added on the 1st of January.
Okay. You will be entitled for the next.
Yes, yes,
Will not say that. Accordingly, Mr. Mojumdar submits that the currency of the punishment was over on he being not paid his due annual increment which fell due on 1/1/2000. 1/1/2000. That will be a better proposition. Better proposition. 2000. Where you get, where you not get, it's a different issue. And accordingly, Mr. Mojumdar contends that on and therefore, Mr. Mojumdar contends that there will be no effect on him being paid the first MSCP which was due on 9/8/1999, and that there will have no effect 9/8/1999 when it was over 2/1/2000. So he will be entitled for the MSCP, even it is assumed that due to currency, such MSCP is not granted on 9/8/1999, he is entitled for such benefit under the 1999 scheme on 2/1/2000. 2/1/2000. That is after his increment due on 2/1/2000 was withheld. Isn't it? Or not 2/1, not 1/1/21. Okay? Okay. Full stop. However, according to Mr. Mojumdar, he has been granted such benefit with a year later, that is 2/1/2001. The second contention of the petitioner is that the second MSCP, which had become due, which had become due on completion of 24 years of service, the second MSCP became due on completion of 24 years of service with effect from 1/1/1983, that is with effect from 24 years?
1/1/2007.
1/1/2007, and accordingly, he was granted such benefit on 1/1/2007. Isn't that it?
Yes.
1/1/2007. Thereafter, modified assured progression scheme was given effect to on 1/9/2008. 1/9/2008. And in terms hereinafter referred to as MACPS. Agot was SCPCS, now MACPS 2008. 2008. The financial upgradation are to be granted at the interval of 10 years, 20 years, and 30 years. Isn't it? As the petitioner has already granted financial upgradation on completion in terms of the earlier scheme of 1989, the third SCPS, third benefit, third upgradation will fall due on 30 years.
That is 1/1/2013.
1/1/2013. 1/1/2013. However, the petitioner has been granted such benefit with effect from 25/5/2014. Accordingly, it is the contention of Mr. Mojumdar that such action on the of the respondent employer in granting the petitioner MSCP with effect from third MSCP with effect from first MSCP with effect from 2/1/2001 and the third upgradation with effect from 25/5/2014 are illegal on the face of the scheme, and therefore therefore a direction should be issued to the respondent to recalculate the benefit in the aforesaid term and give the consequential benefit thereof. Per contra, Mr. Pegu, learned CGSE, submits that so far relating to first SCP in terms of the scheme 9/8/1989, since the punishment was stoppage of increment with effect from 27/4/1999, such punishment shall continue till 27/4/2000. 27/4/2000, and therefore the petitioner case was rightly, petitioner case was considered and rightly granted from 2/1/2000 instead of 2/1/2001 instead of 2/1/2000. Therefore, the respondents cannot be faulted with. Coming to the grant of second upgradation in terms of the SCPS 1999, Mr. Pegu contends that as the petitioner was entitled for first MSCP on 2/1/2001, his second upgradation, he will be entitled for second upgradation only with effect from
24/5/2008.
24/5/2008. That
Due-
is,
Due to the cumulative effect, my lord.
there is no okay. As the currency of punishment was up to 27/4/2000. This is 24/2/2000. That being so, the petitioner will be entitled for the third MSCP only with effect from 25/5/2014 and not from 1/3/2013. And accordingly, the employer is seeking to correct the date of effect of the second MSCP with effect from 2000 is to be corrected with effect from 2000.
They want to give it from 2001.
No, 2008, 2007.
So
Second MSCP should be,
Second MSCP they have given from
no, initially it was given to 2007. They want to correct it.
18/4/2009.
Therefore, it should be corrected from 18/4/2009.
But they have now corrected it to 24/5/2008.
Okay, 24, it should be given from 25/4/2008.
24/5.
24/5.
Last paragraph, my lord.
No, I will provide it both the dictated copy to both of you. Both of you. 25/4. Today we are not concluding it. Conclusion part, after you go through this, then we will dictate what is our determination. I will also go through this text. Okay. Okay. Therefore, Mr. Pegu contests that there is no illegality in the exercise and therefore the writ petition is liable to be dismissed. Heard in part, list for further hearing on such and such. Give this without any heading, anything, just type it, give it both of them Monday, give a copy to me, list this matter on. Let's take it. Now you can rethink, except part of, how many part hard matters are there? Part hard. No, on that date, any part hard matter? No issue, just fix. We'll give a date. Mr. Mojumdar, we'll give it. We'll dictate only. Anything you want to add in this. Okay?
Just dictating that is item number 1. CRPF would just say that the trading period would be affected.
So that's all. I think whether online, I think by mistake I have not recorded any part hard, just remind us. Because we have already heard this matter.
Only issue was that whether training would be on duty.
Yeah.
But the rules say training is duty.
That's all.
And that basic training is duty is there. That could decide the
That cannot be. The way they have treated that cannot.
The basic training is given in the rule and it says that per FR, it will be on government.
Okay, that will record it.
Published. Okay. Happy.
Yes.
I think this clears my lord.
Huh?
By non-speaking order, lordship,
Hmm.
the petitioner has been dismissed from service, lordship, by the summary court. That order sentence is at 66.
Yes.
66.
Who is for the respondent?
so that it's
Okay, go ahead.
Annexure, it's 56. So the proceeding starts by 4:55. Okay. Now the 67, the decisions on charges. My lord, this is my lord, non-speaking order. Now, lord, page 58, lordship, my 50 statements, my lord, report of summary.
50,
58. The statement, my lord, is who possesses lordship was submitted. My lord, one is 58 page, 58 was submitted on 15 to 2018. Very lot.
Just a minute, just a minute. Some other day. Will take too much of time.
Lot of
Huh?
Yes, Lordship, that is why, Lordship, it will take, Lordship, on the point of perversity, my Lord, after it has.
To look into the perversity, we'll have to see the
Yes.
evidence.
My Lord,
Evidence
that
we
may
have
be-
seen one or two. It will take some time.
Lordship, that may be big, Lord. Pending, Lordship, earlier, Mr. My Lord, Bora was at the council, it's yes, Lordship, because of, yes, my Lord, highly candidate of our Lord.
Mm-hmm.
My Lord, Mr. Bora, he was, my Lord, not council, it's yes, but because of, my Lord, unwellness, my Lord. File was handed over to my Lord, petitioner. It is suffering, Lordship. Petitioner also, my Lord, shorted,
His case is that a shot came from outside, so he started firing. And there is nobody who has actually seen coming the fire, but somebody saw him saying that mujhe goli laga,
Make a cry.
make the cry mujhe goli laga, and somebody said that he was firing towards the jungle. So therefore they say that it is not anyway. It will require some application of mine.
That-
As agreed to by the learned council for the parties, list this matter for hearing. 4th of April.
Okay.
19 was adjourned. Huh? Yes, Mr. Goswami, what are these?
My lord, in the first petition, petitioner challenged the inquiry report. Then when he was dismissed from service, then he filed the second. Out of a short purpose. What did you pick?
None appears for the petitioner on call. So Mr. Goswami, learned additional advocate general is present. In the interest of justice, matter stands adjourned and be listed after 6 weeks. 22 matters.